Senate Transportation Committee will come to order and a quorum was established. Last time we recessed, the chair lays out Senate Bill 39 and recognizes Senator Birdwell to explain the bill.
Thank you, Mr. Chairman. Members, in 2021, the legislature passed HB 19 of the 87th Regular, also known as the Trucking Bill, which aimed to curb abusive trial practices in commercial motor vehicle collision lawsuits by allowing the defendant to divide a commercial motor vehicle collision trial into two parts, with the first part limited to evidence about the cause of the collision and the plaintiff's compensatory damages, and the second part focused on punishment of the defendants, if appropriate, through awarding punitive damages. HB 19 would have also codified what is known in the legal practice as the admission rule. The admission rule, which has been used in Texas courts since the 1961 Patterson versus East Texas Motor Freight Lines case, held that if an employer defendant admits that its employee was working in the course and scope of employment at the time of the alleged incident, thereby accepting liability for its employee's alleged errors, then the plaintiff cannot bring claims that the employer defendant was negligent in entrusting a vehicle to its employee driver. Since the employer has already committed to taking responsibility, if their driver was found to be at fault, then only evidence related to proving who's at fault for the collision would be admissible. The admission rule puts plaintiffs and defendants on an even footing to present their case, helping reduce trial times and alleviate congestion in court so that legitimate lawsuits can move forward quickly in a fair and responsible manner. The amendment to HB 19 created an unnecessary exception to the long-standing admission rule, which has allowed plaintiffs' attorneys to introduce into the first phase of a bifurcated commercial motor vehicle collision trial evidence of the employer defendant's negligent entrustment, even after the employer admitted the driver was on the clock in the scope of their employment, essentially defeating the purpose of the bill. SB 39 seeks to make commercial motor vehicle collision lawsuits more consistent and uniform by repealing the admission rule exceptions that were amended into HB 19. The removal of the exceptions will appropriately codify the admission rule, fully incorporating the long-standing case law used in Texas courts for decades since 1961. Members, this bill only affects the first phase of commercial motor vehicle collision trials in the event that the employer utilizes the admission rule and admits that the employee was operating within the scope of their employment. If a company decides to not utilize the admission rule, then all evidence of negligent entrustment will be admissible throughout the entire trial. Nothing we are doing here today affects the ability of plaintiffs to seek to and be awarded punitive damages against defendants whose conduct deserves such punishment. Mr. Chairman, I do have a committee substitute I'd like to send.
There is a committee substitute. Senator Betancourt sends up the committee substitute. Before I ask you to lay out what the differences are, I'd ask the clerk to call the roll.
Nichols.
Here.
West.
Here.
Betancourt.
Present.
Hagenbu. Hinojosa.
Present.
Johnson. King. Miles. Airy.
Here.
Quorum is present.
Quorum is present. So Senator Betancourt sends up the committee substitute and asks Senator Birdwell to explain the difference.
Thank you, Mr. Chairman. Members, the substitute simply eliminates Section 1 of the originally filed bill because it was unnecessary to restoring the long-standing admission rule to commercial motor vehicle collision lawsuits. And members, there are a number of resource witnesses that are available subject to your questions.
Okay,
you,
members,
Mr. Chairman.
questions to Senator Birdwell.
Oh,
Senator West?
I'll wait till it.
Are you going
I'm
to
waiting
wait
till
for the
the
witnesses?
resource witnesses.
Any other questions over here? Or do y'all want to hear the witnesses? Okay, so then we'll open up for public testimony on Senate Bill 39 and the committee substitute for Senate Bill 39. First panel, we'll call up Lee Parsley, Texans for Lawsuit Reform, and the Honorable Eddie Lucio III, as well as Honorable Craig Island and Jim Perdue, Texas trial lawyers. All four of y'all, please come up. And we've got a 2-minute limit, but then we'll open it up for questions, so I know there'll be a lot of questions. Are we missing someone? I've got Eddie.
Mr. Chairman, I've just been informed that
What?
Representative Island had a baby throw up on his suit, and he is on his way. So he apologizes, but he is
Okay,
on his
as
way.
soon as he gets here, if somebody, when he steps in, we'll send him on up. All right, so we can just start with you since you already got the mic. Please introduce, state your name for the record.
Thank you, Mr. Chairman. My name is Jim Perdue, Jr. I am past president of the Texas Trial Lawyers Association. I was president in 2021 when HB 19 was brought through the House side and participated in both its debate and the amendment that is represented by today's bill and Senator Birdwell's SB 39, which in effect repeals that bill. Let me begin, Mr. Chairman, with the layout of the amendment itself that is at issue here today from 2021. The layout of the amendment, as laid out by Representative Lucio at the time, who stated, quote, "I was concerned that in phase one of that bifurcated trial, in the circumstances where the employer defendant did not act responsibly, that the jury would get to consider evidence would be presented that they did not meet basic common sense public safety standards. That was what I brought to the stakeholders and brought to the chairman for consideration, and we wanted to root that in a prudent operator standard, in something that could be consistently applied in every jurisdiction, in every case. So that we decided to do was to root it in federal and state law." The amendment that went on to HB 19 on the floor in the House essentially took the federal regulatory standards, the law that governs vehicles that exceed a certain curb weight. So what you're talking about is a section of this bill that is only limited to the application of 85,000-pound tractor trailers, both interstate tractor trailers and some intrastate loads, but only 85,000-pound vehicles. This bill, which seeks to repeal those sections, in no way affects a plumbing delivery service truck or anything else. It only repeals the law that governs their conduct already, and it affects their responsibility in current law on the civil side. So that was what was voted on, agreed to, unanimously adopted as an amendment in the House, came over to the Senate, and the Senate, when reviewing that, Senator West having participated in that, Senator Taylor then carried that same amendment on what became the Senate-adopted version of HB 19 in the end.
Okay, what I'm gonna do is I'm gonna go to kind of each side here, and we'll wait till the whole panelists make comments, and then we'll open it up for questions. So, Lee, please state your name for the record.
Good morning, Chairman Nichols, members of the committee. My name is Lee Parsley. I'm here on behalf of Texans for Lawsuit Reform in support of Senate Bill 39. I don't disagree really with anything Mr. Perdue has said about the history of this. It is an amendment that went on the House floor. It was an amendment, I think, negotiated in the back hall of the House, and Mr. Lucio can speak to that in some detail by people acting in good faith, unquestionably, all of that. The thing that has happened is that the amendment made House Bill 19, the trucking bill, just dramatically less effective for its purpose. So at the time, the committees here and on the House side that heard the bill heard testimony from many, many, many people who said that trucking litigation in Texas was completely out of control, and there had to be some activity by the legislature to help with that, because the trucking business is vital to our state. And House Bill 19 was supposed to codify the old common law admission rule, and the amendment that went on the House floor is an exception to the admission rule. And the admission rule, by the way, has been in Texas for 60 years. It's adopted by a majority of other states around the nation. So it's not like we're doing anything new. We're just codifying the admission rule. But the exception then, relying on federal regulations, which then rely on other federal regulations, has the effect of making that bill just not very effective. It's just not used in litigation for the reason it was intended. And so I think that the legislature is entitled to revisit something they did that was amended in good faith, that didn't quite work, and then so it's time to come back and revisit that. It's been 4 years, and so that's what I think Senator Birdwell's bill is asking the legislature to revisit a decision made in good faith that turned out to not be as helpful as the authors had hoped it would be.
All right, thank you. We'll go to Craig Island.
Thank you, Mr. Chairman. Sorry to be a few minutes late. I had a 9-month-old throw up on my pants and had to
We won't take
Mr.
that.
Chairman, may I ask a question? Mr. Chairman, now, did the parent take responsibility for the child? Because now,
No, that's why it's with me.
thank you, Craig. Thank you, Mr. Chairman.
Mr. Chairman, members, the way this bill is drafted, the company will never be, the company's conduct, if it's different than the driver and it causes the wreck, will never be heard by the jury. And what is happening in the bill is the exceptions. When the amendment was added in the House and the Senate, the exceptions to say if a company did something wrong, if the loading was improper, if the brakes were not maintained and the brakes failed, that conduct would be presented to the jury, and a jury could assign proportionate responsibility to them. This bill says that the jury will never hear about the company's conduct. And this is where it would devastate an injured individual. Assume that a truck driver is driving down the road, he's being completely responsible, right? He's maintaining a proper distance. He or she is keeping a proper lookout. And there's a slowdown ahead. The driver hits the brakes fail, the driver plows into the innocent victims. What happens under this bill as currently drafted is that when the case goes to the jury, the only two people submitted to the jury for consideration is the driver and the victim, right? The injured person. You say, well, what about the driver tells the DPS officer, my brakes failed. I couldn't stop. It wasn't my fault. And it turns out, sure enough, the brakes failed. Well, what's the jury going to look at? The jury's going to say, was the truck driver at fault? No, it wasn't his fault. He kept a proper lookout. The DPS officer said so. All the physical evidence points that the brake failed. It's not the driver's fault. Was it the innocent victim's fault who got rear-ended from behind? No. Well, the jury can only answer to those two people because under the bill as drafted, the company's conduct the company's not on the line at the jury trial because on A and B, there are no exceptions. If the company comes forward and says we are respondeat superior, we're responsible for the conduct of our driver, then the company is never submitted under the way this bill is drafted because there are no exceptions under A or B.
Okay. So, Representative Lucio.
Yes, sir. Mr. Chairman, members, thank you for allowing me an opportunity to participate today. You know, I had great hope that the work we did.
State your name.
Oh, Eddie Lucio III. Yes, sir. I had great hope that the work we did on HB 19 would have made a difference. I want to thank Chairman Leach and the several other members that were part of that. It was one of my prouder moments as a member because I brought these two parties together who historically have had a hard time collaborating and working together. We spent nearly 15 hours in a room working and fine-tuning the bill language. Instead of being here today, I would much rather our work product from 21 resulted in meaningful reform. Reform needed to ensure just compensation for plaintiffs while protecting the business community from frivolous lawsuits. Since 2021, like many of you, I get calls from small businesses all the time about their rising insurance costs, from chambers about their inability to attract businesses to Texas because of the cost of insurance. Asking, these aren't all big commercial vehicles like 18-wheelers. Some of them are smaller. They're florists. They're other types of businesses. And they call and say, I thought we fixed this in 21. I thought it was going to make a difference. I thought our insurance premiums are going to go down. And having to look further into it, I realized that although we were well-intended with HB 19 and the amendment to HB 19, it complicated things to where it's not practically used in trial courts today. Our amendment, well, HB 19 was to bifurcate trials to determine in phase one liability and compensation. And compensation is a broad term that encompasses a lot of things to make the plaintiff whole. And that's what our justice system, at least that's what they taught me in law school, is to make the plaintiff whole, not to make them rich. In part two, it was to determine if there were bad acts, that either the driver's bad acts or the company's bad acts. And then we would talk about punitive damages. We tried to talk about negligent entrustment with limited circumstances in phase one, but it just confused the system. And we never got to experience the benefits of what HB 19 sought to do.
Okay, let the record show Senator Johnson's here. We're opening it up for questions. I think Senator West, you were first.
Back in 2021, Representative Lucio, who was sitting at the table?
Lots of members were coming in and out, but it was Chairman Leach, then Representative Burrows, Travis Clardy. There was probably 10
Trial
or 12.
lawyers were there.
Excuse me, sir.
Trial lawyers were there.
Yes, sir. Trial lawyer. Not in the room, but we were all.
You know what I'm
yeah,
saying.
they were represented by members. Yes. Sir.
Everyone who's sitting at this table today, their interest was represented in 2021.
Yes, sir.
And you would agree that that was some very difficult negotiations that were going on.
The toughest I'd ever been part of.
Some of the same issues that are being brought up today were brought up then. Would you not agree?
Yes, sir.
Okay, and these well-represented interests in this room had people vying for and also making certain that their interest was considered back in 2021. That's what I recall.
Yes, sir.
Okay, and we struck a deal back there, and that deal ended up being the amendment that was placed on this bill in the House.
Yes, sir, and in the Senate. Yes, sir.
And in the Senate, and now we want to redo the deal.
Yes, sir.
Okay, and the same interest is sitting at the table.
Yes, sir.
Okay.
Can I speak to that? I just want everybody to understand. I'm not necessarily but the deal was Representative Lucio in the back hall of the House with other members of the legislature. I was not there. No one from Texas Trial Lawyers.
Well, I'm not saying
there.
that y'all were present.
Yeah, we weren't in the room.
Let me finish. Would you mind? Okay. I'm not saying that you were present. I'm saying your interest was present, not that you personally were present. That's what I'm saying.
Let me go to Senator Johnson.
Thank you, Mr. Chairman. I wanted to pick up where Senator West left off. Representative Lucio, at the time that amendment was negotiated, successfully negotiated,
Yes, sir.
it resulted in quite a few members of the legislature in the House and the Senate throwing their support behind a bill that they had previously refused to support. Is that correct?
I would say that's correct. Yes, sir.
I can tell you it's correct in the Senate, and I can tell you it's correct as between some members of the Senate that are sitting on this dais. So, the history is not just about compromise among the parties. This bill passed as a result of that compromise. Otherwise, it might not have. Would you agree with that assessment?
It was highly contested. Yes, sir.
And people changed their votes as a result of that negotiation, right?
If I may.
Please.
Yeah, if I may. It was my intention, I can't say everybody else's intention, only my own, to try to have meaningful reform. And the reason, and frankly, I wasn't even working on that bill until 24 hours before it was to be on the House floor. I was called in last minute because it was highly debated amongst members. We were trying to do our best to strike a bill that would not shut the doors to the courthouse for plaintiffs. That is not my intent. But we needed meaningful reform, relief. What I've seen, Senator, I'm a small business owner. I have 2 franchises, is that every year my insurance rates go up. And that's built into my base rent, triple net. But then after that, I still get a $10,000 true-up for each location at the end of the year. And when I call my landlord and say, what's happening? They said, we have these rising costs of insurance. So the compromise was, here's what we believe will provide reform and cut down on these extreme cases that we were seeing growing and growing. And what I can tell you today is that those cases continue to grow and grow. Those verdicts continue to get bigger and bigger. Those lawsuits are more and more in every county. What we did in 21 was never really adopted or used as a trial option because trial courts and lawyers have told us it was confusing in how the standards were, or the ones we built into the bill were going to be used or interpreted at the court level. I think the basis of HB 19, I would have voted for even without my amendment because I believe we need relief. I'm not trying to undo anything. Frankly, I just want an opportunity for an option at the trial court level that would be meaningful to contain and reward plaintiffs justly, but not beyond what I remember in law school as a principle of making plaintiffs whole. And what we're seeing is evidence that prejudices the jury and results in these nuclear verdicts on fact patterns that just are astonishing to me and many of my colleagues that are lawyers that don't practice plaintiff's law, that don't trial work.
Finally, if I might, one more question. Mr. Island, you described what seems like an alarming scenario in which liability is going to go it's going to be foreclosed. Does anyone on the dais disagree with what Mr. Island said about the ability to pursue the owner if they're unable in the first phase of the trial to present evidence of the owner's culpability?
I could not disagree more strongly with everything Mr. Island said. Completely, absolutely wrong about how this bill works. Completely. Under 72.053, you load the truck wrong, it comes into evidence, you're going to be liable as an owner for that. The brakes fail, it comes into evidence, you're liable as an owner for that. This has to do only with the employment-based claims. That is, did your employee, was he drunk or high or whatever? Now, that evidence is coming in too. If the employee was drunk, high, been in the cab too long, all of that's coming into evidence because all of it could have caused the accident. It's all coming into evidence. The only question is it coming into evidence to support a claim for negligent entrustment of the truck? That is the only thing we're talking about here. Negligent loading, negligent brakes, negligent maintenance, all of that comes into evidence under this law today, and nothing you're doing today will change it. I could not disagree any more strongly with what Craig Island said about this bill. It is just simply wrong.
Mr. Island?
Yep. It can come into evidence, but the company's not going to be in the phase one of the trial under this bill as it is written. That's true. Under 053, it says evidence can come in, right? But there's not going to be the company there to assign responsibility to in the first phase of the trial as this bill is written, because under 54A, it says no exceptions. We strike out the exceptions. That's the whole point. The whole point of the amendment in the House to say if you violate all of these safety standards, that's the exception. Under 54A, the very first thing is it strikes out exceptions, right? And then it strikes out C, D, and E over in later in the bill, and it leaves F, but there's no way to get the company into the first phase of the trial under this committee substitute as it's written.
It's just wrong. 74A is based on, says it plainly on the face of the 74A, based only on respondeat superior. Respondeat superior is an employment doctrine. It has nothing to do with negligent maintenance. 74A is talking about respondeat superior. Are you liable for if you concede that you're liable for that employee's negligent actions, you are on the hook to pay the damages under respondeat superior. This whole conversation is about those employment torts. Negligent loading the vehicle is going to be on the jury charge. Nothing you're doing today changes that. I guarantee it. I guarantee it. This 74A is talking about respondeat superior only, and Craig reading it some other way does not make it true. It is, and it's plainly in the words of the thing. And so it's and the exception is except as provided in paragraph D. Well, section D of this thing really makes a mess. Section D of this thing right now today, D1 says, if the trial is bifurcated under 72.052, evidence that is admissible under subsection C. Evidence admissible under subsection C is that the employee was drunk, high, over his time in the cab, and some other things like that. So that evidence is admissible in the first phase of trial only to prove ordinary negligent entrustment by the employer defendant. So subsection D says that the fact that that person was drunk, if you plead negligent entrustment, the fact that he was drunk is now only used to prove negligent entrustment. You can't even use it to prove that he ran the red light. If you read subsection D literally, and court should, you can use the evidence that he was drunk either to prove negligent entrustment or that the employee ran the red light, but you can't use it to prove both. That's the way the thing reads right now. It is not the way the law should work. And so when you take out that exception, when you take out paragraph D, you're doing the plaintiffs a real favor, because right now the evidence is limited to A or B. It can't be used for both. 74D goes further to say the evidence admissible under subsection C is the only evidence that may be presented in the first phase of the trial on negligent entrustment. So you didn't train your driver to drive a particular kind of vehicle. It has a particular kind of load. You didn't train him to do that. That would be negligent entrustment, potentially. Your failure to train the driver, and therefore you've put an untrained driver on the road, is negligent entrustment. Under D2, it's inadmissible because it's not drunk, high, overtime in the cab, or the other things that are listed in paragraph C. This thing, paragraph D, actually says that if you plead negligent entrustment as a plaintiff in one of these cases, you are limited to this little sliver of the world of negligent entrustment, and you can't even prove that the person was improperly trained about how to drive his truck. That is literally what the amendment that went on in the House says, and that is literally why it's not working today. It has nothing to do with negligent maintenance, nothing to do with the brakes. It has to do with the employment-based tort negligent entrustment. Did you put somebody in the cab who shouldn't have been there because they're a bad driver?
Okay, let the record show that Senator Hagenbu is here, Senator Miles is here. Senator Johnson, did you get your question? Yeah, you just turned it off. So we'll go to Senator Hagenbu. I think you had your light on first.
Yes.
Question?
Thank you, Mr. Chairman. Mr. Lucio, you're an attorney and a former state rep, correct?
Yes, sir.
So, and you worked in this bill at some length, right, to try to get it right and make it fair and just, sort of fair and reasonable on all sides, correct?
Yes, sir.
Yeah, then it's you.
And you've decided that the Lucio amendment doesn't make sense at this point, correct?
In practice, it has not been used because the feedback we get is it's confusing trial courts, it's confusing plaintiffs and defendants, and only the traditional method of trying cases remains.
And I'm not a lawyer, sort of pull up and put it in layman's terms, I think. The intent of the law originally was to make sure that the first phase of the trial was straight up, what are the facts and who's basically at fault, right?
Correct.
Without bringing in a bunch of years of information about the trucking company, as long as they, I don't know legal language exactly, as long as they stipulated that the driver worked for them, then it was just based on the facts of the case. Wasn't years of all kinds of information about the trucking company from 30 years ago or all kinds of stuff. It was based on what happened at that point in that accident, correct?
So, correct.
That was the intent of
the original bill. Yes,
right.
sir.
But because of this exception, which we're talking about right now, which we're still one of the gentlemen here is still trying to get back in again or keep in, the exception ruined that attempt to try to make sure that it was just based on the facts of the case, correct? Basically, right?
That is the feedback we're getting
Yeah.
from practicing trial lawyers. Yes, sir.
Yeah. Thank you very much.
Yes, sir.
All right, Senator Perry.
Thank you, Mr. Chairman. A couple of things. One, the conversation around we're now changing something. We make laws every day in this Capitol for 140 days that when we come back 2 years, 4 years, we figure out whether we got it right or not. So that's not unprecedented that we change bills. I'm not an attorney. I've said this before in other hearings that you guys show up. Just in a layman's perspective, and I don't care who answers, if I'm wrong or right, you're not going to hurt my feelings. If I killed somebody today, the first part of this conversation is to determine, did I kill somebody today? If I had killed somebody 30 years ago, that's not part of today's presence. That doesn't interplay on today's trial for what I did today. However, the next piece, you get to bring up the fact that I've killed people in the past. Am I looking at that right? That you get to bring in other facts to kind of determine at what level maybe I'm not a good person. So So just in a layman's perspective, it's about today, and what I understand the friction is we biased the jury was past, kind of your part, but in just a very simplistic term, it's about what I did today, no matter what I've done in the past in the first part. But in the second part, you get to tell everybody that I'm a really bad person. Is that kind of a
Senator,
layman's perspective?
If I may, as I understood it and how we talked about it is that companies pass acts that in most cases had nothing to do with the cause of that accident when brought into phase one of the trial could prejudice the jury.
No, I agree with that.
Right. So what we wanted to say is, okay, let's clear the path here and just talk about who caused the accident, what was the cause of the accident,
Right.
and determine compensation. When an employer accepts responsibility for the driver, then negligent entrustment in a typical case is not a plea anymore. They accepted responsibility for the driver.
So in my example, if you don't tell them I've killed someone in the past in the first phase, I agree. If you tell them this guy's killed people in the past, that's going to prejudice the jury. It's
They're
human
gonna,
nature.
Right. Human nature
right?
is going to say they probably killed
So
this guy
I just
too.
want to make sure this CPA, layman kind of perspective, is kind of getting his head around what it's working. Because the truth of the matter is, attorneys make it more complicated than it should be most of the time.
Wait a minute.
So,
Go back down here. All right.
I think he wanted to respond to Harry's question.
All right, you're going to respond?
yeah, I was just going to, so Senator Perry, you're talking about a criminal scenario, and I think that your reading of the idea of punishment, right, in a criminal trial is correct. But the concept of accountability in phase one, right, is not temporal past acts to prove negligence in phase one. By very definition, I can't use things that are not relevant to the responsibility of the company that caused the wreck. The question is whether a company that has 80,000 power units driving 85,000-pound tractor trailers across the United States of America has a responsibility beyond simply saying that's our driver. And the law says it does. But for these people that have been injured by somebody, like that wreck on I-35 last week, you've got a foreign national with a questionable CDL with 3 priors and a pending speeding ticket on the driver's record known by the company that has put him behind the wheel. And the company says, that's our driver. But we sent him out. We knew he was dragging down the road, and he comes into a construction road zone doing 80 miles an hour, knowing that he's got these issues on that day, not past, on that day. And he plows into a family of 4 and kills them in a construction zone. Now, under this scenario, if this gets all repealed, the company says that's our driver and comes in and defends the case in 3 ways, because I actually try these cases. The first thing they do is they say, Williams Brothers Construction failed to have traffic safety controls, and they should have limited speed earlier down the road so that that truck driver never hit that family. And then they responsible third party in a disabled car in those 2 lanes of traffic that had caused everything to focus and get into the ukulele or accordion situation it was in. And they say they're responsible. And then they defend the case by saying Williams Brothers needs to be submitted, the disabled vehicle needs to be submitted, and the driver of the plaintiff's vehicle that didn't get out of the way needs to be submitted. But the only thing the jury can know about, the only thing the jury can be asked about is whether our driver should have slowed down earlier. But we're going to say all these other people are at fault. It is very much a temporally connected causative standard, and it cannot be just extra stuff. That is true in the exceptions as they were drafted by Mr. Parsley himself, by the way, by the constituents that were at the table, and that's what we want to achieve.
Let me ask it this way, but in the second part, the fact that the employer in your example, your real life unfortunate example, that employer would then be identified as having all these other factors in the second phase. And I'm just going to play a little bit of a devil's advocate here. I've heard you say in multiple settings in different hearings, trust the jury. And what I'm getting to is, if that evidence is presented in the second part, do you not trust the jury to weigh in on what is compensatable and what's not and at what number? So you know, it's you either trust the jury all the time, or you trust the TV none of the time.
I'm pretty uniform in trusting the jury, phase one or phase two. I think there's some members of the defense bar who are available to talk to you today about the challenge of this bifurcation idea. Yeah. Because one of the unique things about this bill, as it was designed, the flower delivery truck, the box truck for a plumbing company, small businesses, they are not affected by this section, right?
And I appreciate those nuances, but I'm just trying to get down to the core of it. At the end of the day, all of the evidence is presented if you have 1 and 2.
But my only point that I was going to make, Senator, was a smaller company that's got a commercial vehicle policy, an auto policy for their company, they don't cover punitive damages. Big rig companies running interstate loads, they do cover punitive damages.
Yeah,
their tower will.
I think the way the insurance companies work, whether they cover them or not, the cost of everything in their portfolio is amortized over the cost of the ratepayers. So if I have a $100 loss today and I have 100 premium owners or payers, they're going to put $1 to every one of those. That's just how it works, and then they mark it up for their margins. I mean, insurance companies really have a sweet deal, right? They have a business model that they never lose.
That's true.
So in that regard, it's just a pile-on. But I'm just so as a legislature I can get it. That's how I understand it. First part doesn't let them talk about how bad a guy I was in the past, or some of the culprits that may have been bad actors in the past that have a history. But that does come out in the second part, and jurors get the benefit at that point. They haven't determined how much they're going to compensate, right? The second part's about all of that, and they're going to do it based on all of these facts that you're afraid were not put in on the front end. So that doesn't get lost in that bill, correct?
Well, except for the last part about damages, because they have compensated at the end of phase one.
Okay, I get you. I appreciate it.
All right, we're going to Senator Hinojosa.
Thank you, Mr. Chairman. Just to follow up on Senator Perry's questions, Senate Bill 39, the way it's written, it actually deletes and does away with Section C under Section 772.054. It lists there in detail all the evidence that would be admissible, the exception. So that evidence that's being deleted or taken or omitted, if you will, from the Senate Bill 39, is there any time in the trial itself that you're able to admit that type of evidence? Is that on the second phase of the trial?
It comes in on the first phase of this list is what's admissible for proving negligent entrustment. It's not a list of what's admissible just generally in litigation. And so if the driver was drunk, which is on this list, that is normally admissible in a trucking vehicle accident case, because whether the driver was drunk or not has some evidence of whether he caused the accident. So the drunkenness of the driver, whether the driver's high, that's going to be admissible in a case without, you take paragraph C out, it's admissible. You leave paragraph C in, it would be admissible, except it can only be used for one thing or another. But that's admissible. That evidence, all the things in C, if to the extent they are likely to prove that the driver of the truck was responsible for the collision, are admissible.
Well, what about the employer?
That's what paragraph C is talking about, is whether that evidence can be used to prove a claim for negligent entrustment after the employer has agreed to responsibility under respondeat superior.
Okay, so then what is the difference, I guess? We're talking about at what point during the trial is the evidence introduced?
The evidence...
Right now, it seems like it's introduced at the first part. It's a bifurcated trial, introduced at the first part. And from what I'm hearing is that now it'll be introduced on the second part.
Yes, right now, whether the way this thing, because it refers to a whole bunch of Code of Federal Regulations. This is literally true. I can give you the cites if you'd like them. The Code of Federal Regulations then refer to other codes of federal regulations. So you've got this pyramid effect from what that amendment. So today, it may be admissible that the driver was drunk when as negligent entrustment, but under some codes of federal regulations, it would be admissible for negligent entrustment under this bill if the driver was drunk and has been convicted of DUI. Some federal regulations require that he be convicted of DUI. Other federal regulations referenced here in this pyramid don't require he be convicted of DWI. So which is it? Is this law that you've got to be, you can use the evidence if he was convicted, or you can use the evidence if he wasn't convicted? That's the level of things that are kind of out of whack with this amendment that went into the bill. If it just comes out of the bill, what you end up with is that if the driver was drunk or had been drinking, the plaintiff can show that to the jury and say, look, it is evidence that he caused the accident, that he had been drinking.
So if they can show at the trial that the first phase of the trial on damages, you can show that the employer knew that driver had a suspended driver's license or had two other movement violations. Can they show that in trial?
If you take this out, they would not be able to show that at trial if the company agreed to that they are going to pay for the liability under respondeat superior. And that has been the law of Texas since 1961. It's been the law. It is the law in a majority of states in this nation that once the defendant company says, I am responsible to pay the full amount of this claimant's compensatory damages, he was in the course and scope of employment, all those employment-based torts fall out of the case.
Okay,
It's
so
the Patterson
now,
case from
I
1961.
understand that. So at what point can you introduce that type of evidence?
In the second phase of the CMV trial to prove that the company was grossly negligent in turning the car over to this vehicle, the CMV over to this person, it can be used in phase 2 to punish the company.
And on phase 1, you do actual damages.
In phase 1, you do actual damages, which don't change based on the company's conduct.
And on phase 2, it's gross damage or gross negligence.
So that's correct. So phase 1, as you know, you've done this for decades, I think, at this point, as have I. Phase 1 damages are compensatory damages. They are plaintiff-focused. So if the car crash broke my arm, then it costs $5,000 to fix the arm. It doesn't matter if the driver of the CMV was drunk or has a 50-year perfect driving record, it still costs $5,000 to fix my arm. That pain that I received from having a broken arm is the same whether the driver was drunk or the driver had a 50-year perfect driving record. That's the pain. I still feel the same amount of pain. I still feel the same amount of mental anguish. I still miss the same number of days of work for which I'm compensated.
The evidence come in on the gross negligence side, right. Second phase.
So reason once they comp to respondeat superior, they have to pay the $5,000 for the broken arm. They have to pay for whatever pain you suffered. They have to pay for whatever mental anguish you have, for whatever work you missed. They have now said, I'm going to pay that, and those numbers don't change by the badness of the defendant driver's conduct or the company's conduct. Those numbers are fixed based on the plaintiff himself or herself. That's why this rule applies. The admission rule is always applied for the reason that it doesn't change the outcome for the plaintiff. He still gets the same amount of money for his plaintiff-centered damages, and it simplifies the trial for everyone else. So the jury hears a whole lot less evidence that it doesn't need to hear because it is not relevant to any decision left in the case.
So is the objective just to simplify the trial?
Yes, sir. It is
Expedite
simplifies
the
the
trial.
trial.
Nothing to do with maybe present bias evidence
Well,
from the defendant's point of view?
So the case law out there across the country, I mean, again, it's across the country. The courts will explain it, just as you're describing. You get a simpler trial. The evidence, the amount of damages shouldn't change. And if the amount of compensatory damages does change, if you get a lot more pain and suffering damage because the person was drunk versus they have a 50-year driving record, that's actually inappropriate. The amount of your pain and suffering should be tied to just what your injury is, not to the badness of the defendant's conduct. So if that number is changing, which is what the plaintiff's lawyers want it to do, they want it to change, they want you to get more pain and suffering damages, the law is that's actually inappropriate. That's what the admission rule says. The only way it changes the outcome of the case is a way that's inappropriate. It changes the pain and suffering damages when it shouldn't.
Thank you, Mr. Chairman.
All right, Senator Hagenbu, and then after that, we'll go to West and then Johnson. So Senator Hagenbu.
Thank you, Mr. Chairman. I want to give Mr. Parsley and Mr. Lucio's opinion on this. The gentleman next to you, they gave you the pretty extreme and recent case where it sounds like a lot of that immediate information would be admissible even after this law. I want you to comment on that. But in practice, what this law is trying to do is there's situations where lawyers are not bringing in to the case just missing some of the immediate stuff. They're bringing in things from many years ago, and not just talking about the exact accident at hand, or even what the Senator Perry was talking about, former bad accidents, but even just going into diving deep into the trucking companies' policies on safety and saying they didn't follow this policy, they didn't follow that policy, and all kinds of other information that they're bringing in, not just immediate things or even information about previous accidents. In practice, they're bringing a lot of other information, pretty much everything they can dig up on a trucking company, and trying to bring that in the first phase of the trial. What they're trying to do is eliminate that so that you can just the jury can focus on the facts. I'd like you both to comment on that, if I'm accurate on that.
99% of the time. So let me first say what happened here with that family is tragic.
Absolutely.
Heartbreaking. I no words to console them. 99% of the time, they're going to settle that case for maximum value, and they're not going to.
As they should.
As they should.
Yeah.
In the rare case that it does go to trial, if this bill were to pass, you would talk about compensatory damages first in phase one, and liability. And then to Senator Hinojosa's point, in phase two, you could talk about the bad acts of the company. You would still get to the end result of what happens today, but it would be in a way that's more structured and can provide more accurate findings and results in phase one and phase two. That's as simple as I can put it.
And in practice, what's happening, though, is there's a lot of other examples where there's cases where it wasn't so clear, wasn't that extreme case, yet we bring in years and years of information, not just about previous accidents, but all kinds of safety practices, et cetera, and try to make them bear on the first part of the trial, which is supposed to be talking about just the facts of the immediate case at hand and who's at fault, right?
Compensatory damages, again, are to make the plaintiffs whole. What were your expenses? What were your medical expenses? Did you miss work? Are you going to have a lower capacity to make earnings in the future? And pain and suffering. What happens when you introduce evidence that, like I said, and most times is not the approximate cause of the accident, is it prejudices the jury in pain and suffering. Pain and suffering should be more of a mathematical question than, a large subjective jury award. But the punitive side, the punishment side of it, that is where if a company acts poorly, if a defendant acts poorly, a driver, that's where they're held accountable and hopefully deterred from acting that way in the future.
Would it surprise you to hear that if some trucking companies and lawyers would advise them not to have any safety policies at all, so that that in the future, if something like this happens, that a lawyer can't say, well, you didn't follow one of your safety policies 10 years ago, one small one, and bring that into the first phase in the current situation?
It would not surprise me. There's bad actors in every phase of this, on all sides of this, that, frankly, act in a way that put us here today, whether it's the plaintiff side, defendant side, insurance side. There are people out there causing problems, and that's why we're having this discussion.
Yeah, thank you, Ms. Parsley. Ms. Parsley, you have any comments on that?
I actually don't think I can add much to that. You've described, I think, what's happening in the courts a lot is there's an effort to bring into evidence a lot of evidence that's supposed to indict the character of the company in order to increase the damages in the first phase of trial. And that's
Thank you. Thank you, Mr.
But the only thing I will add, that this all is built on the need for the company to admit respondeat superior. They have to say, I'm going to pay this person's damages. And once they do that, then this bill really comes into play. If they don't do that, if they don't say, I'm going to pay this person's damages, sort of all bets are off.
I understand.
Sense, right.
Yeah. Thank you, Mr. Chair.
Senator Birdwell is the author, so he had something he's been waving at me. Go ahead, sir.
Thank you, Mr. Chairman. I want to follow up on Senator Hinojosa's line of questioning, if I may. In your explanation, Lee, you talked about what's admissible and what's not. If the company, I want to make sure it's clear, if the company does not admit the status of the driver as being respondent superior, the company being respondent superior, if they don't admit that, everything that Senator Hinojosa talked about what's admissible, that you said is not admissible in phase one if the company says we're respondent superior, but if they say we're not respondent superior because the driver is not in an authorized status, then everything that Senator Hinojosa talked about is in fact admissible in phase one. Is that correct?
That's correct. You have to make that admission. You have to be willing to say,
Right.
that was my driver in the course and scope of employment, and therefore I am going to pay these damages.
Right. And the admission, members, the admission, and again, Lee, correct me if I'm wrong, the admission is not an admission of culpability, liability in the accident. It is the admission, it's called the admission rule, because it is the admission of the company that the driver is acting in the legal scope of their employment. That's why it's delineated as negligent entrustment. But the bill does not affect loading, maintenance, other things. It's simply in the entrustment status of the driver. Is that clear, Lee?
Well, I think our
Correct.
concern, Senator.
Well, hold on. Let me. I want to hear your concern, okay? But I want. Lee, is what I said is correct?
That's correct.
Okay, Mr.
And
Perdue.
and this, I can leave it to you because it was Representative Island's point. If that is the intent, and I believe that as the author, you would speak for the intent, and I've heard Mr. Parsley, regardless of these victims and dismissing their damages, say that the intent is to allow that evidence admissible under 053, the exceptions, the legal violations that are causative of the wreck, that a load or a maintenance of the truck, all of that is supposed to be admitted. If that is the intent, then there is a fix that can clarify that intent. Because our concern, Senator, is when you read, and I've heard it kind of spelled out both ways by the other side. The intent is to have the admission rule and no evidence can be admitted if they make an admission, but we admit also that a brake condition or company's independent negligence that violates the law that is causative of the wreck can be admitted. If that is true, then that is admitted to support an independent claim. And the way the amendment works to revise 054A does not recognize that independent claim. So we would offer language to the author. It sounds like it's acceptable to the people who brought you the bill that would make that clear that those causes of actions still exist as exceptions to the rule codified in 054A. And with that fix, this bill can be massively clarified and improved.
And
I'm not going to negotiate your bill, but for Lee Parsley and Texans for Lawsuit Reform, we agree that if it's negligent maintenance, if it's negligent repair of the brakes, if it's negligent loading of the truck, the load shifts and causes a problem, all of that should not be affected, in our opinion, by this amendment. And if something needs to change in the words of the statute to make that clear, TLR will be happy to meet you at the bargaining table and work those words out.
Well, if we don't go to the bargaining table, we say every word is your words and it's not going to ever get changed. But I'm offering something that I think would be productive, Senator, and we stand ready to do that.
Sounds like y'all are almost getting there.
Let's finish Birdwell. I want to finish.
That was my conclusion. Thank you, Mr. Chairman.
And I.
Greg, you about to say something?
Yes, sir. Yes, sir. Senator Birdwell, just one comment. We sat through the Senate Bill 30 hearing the other day, and some of the stuff that we heard was that insurance companies are not taking these trucking cases to trial, and they're settling them without the trucking company's authority or approval, and then they raise their rates because they settled the case, right? We heard a lot of stuff about that. And one thing that medical malpractice has, that doctors have, that nobody else does, is the consent to settle. And if that's not in this bill, but if that's something that should be considered, if that is one of the complaints. And finally, we've been here, well, I was here for 20 years, and insurance rates go up every year on every line of business, no matter what we do. So if this bill is going to change for a reason, I would implore you not to change it because you think that insurance rates are going to go down if you change it. Because until we regulate insurance companies, we're not going to have any control or influence over that.
I've heard that one before. It seems as though that y'all are almost talking about being able to get some sort of agreement. Let me make certain that people understand. When these cases are filed, is the company a party named?
Yes.
Okay. And if a company turns around, Lee, and admits liability in the first phase, are they submitted in the second phase also, during the punitive phase?
Depends on the findings in phase one. You can only get to phase two for punitive damages based upon the findings in phase one.
Right. And let's assume that we have the findings to get to phase, the bifurcated portion of it. In phase two, what evidence can be presented against the company?
Well, so according to the language that was passed in 21, what can be presented in phase two has to be different than that which was presented in phase one. And it goes then to essentially what they're trying to hide from the jury in phase one about the company's. So a concrete example, if the driver does not have a commercial driver's license that allows him or her to drive an 85,000-pound truck, which is required by federal law, that is excluded from the jury's knowledge by repealing this amendment.
In which phase?
In phase one. Mm-hmm. Because it is the Lucio amendment, it is the amendment that I iterated that law that identified it as an evidentiary exception admissible in phase one. So when you repeal that section that says if a driver is driving without a CDL, that's admissible in phase one, that means it's inadmissible in phase one, and it becomes admissible in phase two only for punitive damages. That's exactly what the bill says.
That's just not accurate. It says if you take out paragraph C, it says it's not admissible to prove negligent entrustment. It is still admissible that the person didn't have a driver's license to prove that they are more likely than not the person who caused the collision. That there's a difference there. And what happens in this bill currently is it literally says that if you admit that information as negligent entrustment in phase one, that he didn't have a commercial driver's license, the jury must be told that it is only admissible to prove negligent entrustment. It can no longer be used to prove that he is the person who caused the accident. Paragraph D of that amendment literally says that. It has to be used for this or that. It can't be used for both.
So the jury would get a limiting instruction?
If this bill is read correctly, that is exactly what paragraph D says. They would have to be given a limiting instruction, told that the fact that he didn't have a CDL is only considered in the negligent entrustment when you're deciding whether and that makes no sense at all. So that's part of this, it just doesn't make sense. But if you just take C out, the fact that he didn't have a CDL, he or she didn't have a CDL, is relevant to whether he or she caused the collision, was capable of driving the truck. Just like whether or not he or she was drunk, just like he or she was over their time in the cab or high or looking at their cell phone.
I haven't tried any of these cases, but Representative Lucio, you made a comment about pain and suffering being more mathematical than anything. Elaborate a little bit more on that.
Well, pain and suffering in phase one as part of compensatory damages.
Right.
There are experts that have done this so many times that they can provide a more accurate number if the jury isn't influenced at that point with, let's say, bad acts of the company that in some cases aren't the proximate cause of the accident, and they will get to one number. If they're evidence, for example, whether or not the person had a commercial driver's license doesn't change the pain and suffering of the plaintiff. It's not a proximate cause of the pain and suffering of the plaintiff. The pain and suffering of the plaintiff is his experience with his injury. Now, it should be used for whether or not we punish the company for entrusting or allowing someone to drive one of their vehicles without a CDL, but it shouldn't calculate into the number for pain and suffering. But when everything is introduced the way
You don't think a jury should be able to consider that?
For compensatory damages.
For compensatory damages?
Correct.
You don't think a jury, and I know in terms of the consultants and all that stuff to testify, but you don't think a jury should be able to take into consideration whether or not he had a CDL in deciding what the compensatory damages are as part of what they take into consideration? It shouldn't be the determinative factor,
I believe that that's the intent of the law, not necessarily what I feel should or should not be. I think the intent of the law is to compensate them for their pain and suffering and not include in that portion of the damages punishment of the company.
Okay,
Go ahead.
The problem, Senator West, is that you have the question of liability. So phase one, you have question one. Did the negligence, if any of those named below, proximately cause the wreck? Question two then asks for a jury to compare the fault. So under the scenario that he's talking about, if you hide from the jury that they have a driver that is at 16 hours drive time when the federal regulations limit it to 10, and the company knows it, and the company admits he's their driver, they get to hide from the jury their knowledge that they've got a guy who is sleep deprived heading into a work zone. And then in the second question of phase one, say, put 40% on the company. When the reality is the evidence supports 80%, 90% on the company. And that goes directly then to the measure of compensatory damages at the end of the case. Not the number, but the judgment formation of the number based on the percentages. So this legal fiction that they want to insert in directly affects the way our law looks at comparative fault. That's the problem.
All right, Senator Johnson?
Thank you, Mr. Chairman. This bill as proposed, does it create an incentive for an owner to cop to respondeat superior in order to prevent and preempt exploration of other potential causes of the accident that might not be respondeat superior or the fault of the driver? And are there cases where, we're not really sure if the driver was at fault or it was the bad loading, and the jury needs to explore all of that in phase one of the trial? Don't I have an incentive as an owner to just, let's preempt our bad loading stuff and our prior knowledge and just cop to the respondeat superior?
There's a concrete example in the precedent in the state law of Texas, a case called United Reynolds, where they put on a flatbed trailer a boom lift that exceeded height. And the regulations for the company says if you're going to put a height on this flatbed, it's not going to be able to drive certain roads, so you've got to file your drive plan. Company doesn't do it. They send the driver out. He's got a 14-foot high, runs into a bridge, knocks the bridge into a car following, and decapitates the driver behind him. Now, in the scenario of this bill, that company can stipulate that the driver is in course and scope, and the driver says, I didn't do anything wrong. I was driving the route they gave me, going the speed limit. And under the scenario that you offer, the company's responsibility for putting that load on that truck and setting that route will never be submitted. That's what this bill would do.
You say it would be submitted in phase two, right?
No, phase one. That is just wrong. That is in phase one.
Phase one, how? But
it is negligent loading of the truck is not, respondeat superior doesn't apply to negligent loading of the truck.
But doesn't the bill say that once you say, I admit respondeat superior, we're done talking about anything else?
No, it just doesn't.
Explain that. It's important.
It's just not the way it works. It's respondeat superior would be if the driver of the truck was negligent in the way he drove the truck. I say he was in the course and scope of and I'm going to assume that responsibility for paying that judgment. Negligent maintenance, negligent loading is all an entirely different category. It has, and so, again, this entire section of the bill has to do with negligent entrustment of the vehicle. Negligent entrustment of the vehicle does not include negligent loading, negligent maintenance, negligent any of that other stuff.
I'm not going to argue because I think there may be some light here. It sounds to me like there's some light here.
I've already agreed with him on this. If the bill can be read,
and I'll step back because I think there's some words that could be added to this to make it clear that you're not the bill does not preclude the other causes of action being pursued and findings being made in phase one of the trial.
I said that a minute ago. I don't think that's what it says, but if it needs more words to make that clear, I and TLR Senator Birdwell is the author of his bill. He can choose to do whatever, but I'll sit at the table in good faith, as I have every time I've ever sat down with TTLA, to make sure those words reflect that.
Very much appreciated.
Okay, that's great. Senator Hagenbu?
Yeah, sorry, this may be a little bit redundant. I'll be quick here. Thank you, Mr. Chairman. Mr. Parsons, what I understand is, it's going to follow up that, but what you're attempting to do is not eliminate things that really apply to the loading, the immediate things that happen to that case. That should be included in to figure out who's at fault, right?
Right.
What we're seeing is cases where a lot of much older information is coming in to prejudice the jury against the trucking company. But anything to do, that's what this purpose is, right? It's not, the purpose isn't to try to eliminate or hide information that's pertinent to the accident, loading, the condition of the driver, those kinds of things. Those all are intended in this bill to remain and be able to be used in a trial. You're trying to eliminate things that are truly prejudicatory that don't apply to the exact, to this case at all. Is that accurate?
That's accurate. It's the difference between dependent direct action torts and those that are not dependent. And the dependent direct action torts, like negligent entrustment, negligent training, negligent supervision, are dependent on showing that the driver of the truck was wrong, was negligent in how he drove the truck. Negligent loading is not dependent on how the driver drove the truck. Negligent loading is itself a problem. So there's a distinction there in the law and in what this bill does, and you're right about that. So I agree with what
Well, if you all can work out language where you agree, where you're trying to do the right thing and make sure that everything's included in the case, determine who's at fault for the facts that happened, including immediate things beforehand, but not include old information that's irrelevant, then I think that's what you're trying to achieve here, and I hope you can work it out together. Thank you, Mr. Chairman.
Sounds like there's a willingness to have a clarifier, for lack of a better term. It's his bill. But members, we also want to point out we have 50 more people who wish to testify. I'm trying to get through this thing before we go to the floor, so everybody doesn't have to wait and come back. So
I will say, Senator, we stand available, and we will be.
All right, thank you very much. So I know y'all be getting with them. With that, we'll start calling up other people, and I will be enforcing the 2-minute rule, members. Jack Walker, Will, looks like MOYE, TTLA. Will, if I said it right. Moy, excuse me. Hunter Kraft and Jeremy Duke. Jeremy Duke, y'all please come up. I would ask each of you to, that's 4 on the panel. I'm only seeing 3 up. Jeremy Duke. Is he coming? Okay. Just please come up. And we are going to enforce a 2-minute rule. So when you see the yellow light, you're halfway through. When you see the red light, I'm asking you to stop. I would rather y'all stop than me have to cut you off. So we'll start on this end. Please state your name for the record and your position on the bill.
Thank you, Mr. Chairman. My name is Jack Walker. I'm the president of the Texas Trial Lawyers Association, here to testify in opposition to the bill. What I want to talk to you about is one of the myths that you hear about this and what you're going to hear today from a number of witnesses. The myth is that lawsuits and runaway juries are the cause of skyrocketing insurance premiums. This is actually a fear-based narrative that we have dealt with the last 30 years that's actually prompted by the insurance lobby. But it's not true, and it's never been true. So I want to talk to you about some numbers. During testimony today, I expect you're going to hear a number of anecdotal stories from trucking company owners who say, look, we're going to go out of business because my insurance premiums are going up. Everybody in this room is dealing with insurance premium rising. It has nothing to do with lawsuits. But I want to talk to you about the numbers, because in 2024, the property and casualty insurance industry, from AM Best, they made $169 billion in profits. That's up 90% from 2023 when they made $89 billion in profits. That's a 90% increase in 2024. So the insurance companies are making massive profits, but insurance premiums are not going down. The actual drivers of insurance premium problems are inflation, which we're all dealing with, climate change, We've got more and more severe weather-related events. The cost to repair vehicles is up 20% in just 1 year because we have much more advanced vehicles, and they're much more costly to repair. We've got more drivers on crowded roads. These are the drivers that, by the data, is what's driving insurance rates, not not lawsuits. Now, what I would tell you is follow up on what Mr. Island said a minute ago. For 30 years, we have heard that that if you've passed this bill, that you're going to lower insurance rates. That has not been true, and we've got 30 years of data that show that. Each time this happens, it does not lower rates. Thank you.
All right, thank you. Please state your name, sir.
Yes, Mr. Chairman, my name is Will.
Turn the mic toward, just so.
Sure, thank you. Apologies for that. My name is Will Moy. I am testifying in opposition to the bill. I have a small trial practice in Houston, Texas now since March 2023. The relevance, though, of my conversation with this committee is the fact that I was a 25-year insurance defense lawyer, 20 years at one of the state's largest and most prestigious insurance defense law firms. I was a member of their management committee, and I tried cases all over the state. I've handled probably as much trucking litigation as any defense lawyer in the state over the last 10 years. And I'm going to offer this committee my insight with that unique position in that if it ain't fixed, don't break it. Because there's a reality this bill is built on, it's defense specific. Only the defense can elect to utilize it, and it is an elective exception. And there was commentary earlier about it's dramatically less effective, it's not practically used, and there's a reason for that in the old bill that the new bill is not going to cure. And as a defense lawyer, I'll explain it to you. Now as a trial lawyer. The mom and pop problem is a problem because a defense lawyer has to make an election to, I'm going to bifurcate this case for this mom and pop trucking company, and I'm going to try the first case for compensatory damages. And then I'm going to put a mom and pop trucking company into a punitive phase with no insurance whatsoever. There is no insurance available on the domestic or international insurance market for a mom and pop trucking company. It is available for international trucking companies, interstate trucking companies that are in Phoenix, in Florida, in the Midwest. The reason this bill does not need to be changed because it is used the right way. It is used by the defense bar to protect large out-of-state companies for their internal problems that a jury needs to benefit from. It does not help small business. It hurts small business.
Thank you. Please state your name.
Chairman, my name is Hunter Kraft. I'm a trial lawyer from Houston, Texas. I heard some stories earlier, and I'm disturbed about this mom and pop approach. As I continue to litigate, what I am finding out is these, quote, mom and pops are often foreign companies. For instance, a gentleman from a foreign country living in his basement in Chicago who is hiring sight unseen and unvetted drivers who are driving around Texas roads in the Permian Basin, who recently took the lives as he was high of two of my clients. That is the mom and pop that we are seeking to protect. But what I really want to understand is, what is the problem? What are we driving at? And I keep hearing the term nuclear verdicts. And what I think is important for everyone to understand is what the term nuclear verdict is and where it came from. It's what its genesis is. It's not in the law books. It was invented by an entrepreneurial defense lawyer in 2021 from California. He invented this term, and then he took a trademark out on it and began selling books, selling seats to seminars, and selling software to people so that they could identify this never-before-defined phenomenon of nuclear verdicts. The people that are making the money off of this craze is a defense lawyer who now has a team that he calls his special forces that he halos into these situations. This whole insinuation of nuclear verdicts are not backed by the statistics. And if there are questions from the panel, I can go into specific statistics. But as we look at TLR's definition, as I appreciate it, for nuclear verdicts, if you look, the fact is that between 2021 and 2025 in the state of Texas, less than 5% of plaintiffs' verdicts, less than 1 in 20 ever meets this, and not a single case has been upheld by the appellate court.
Thank you, sir. Mr. Duke.
My name's Jeremy Duke. I'm from Ennis, Texas. Mr. Birdwell, you're my state senator. I want you to know how this has affected my family. I'm a fifth-generation Texan. We've been in Ennis for over 100 years. In January of 2015, my baby brother was killed by a foreign Canadian-owned Middle Eastern trucking company. The foreign truck driver was intoxicated, backing up on 635 and I-30 in Mesquite, Texas. After he missed his exit carrying a load of avocados, my brother rear-ended him and was killed. I got at the one in the morning phone call that basically they asked me to come down and identify my brother, so I did and had to ask them to clean him up before my mother came in to identify him as well. This caused a great deal of pain in my family from this loss. My brother left behind a wife and a 2-year-old son, and I'm with my family now raising my nephew and looking after my sister-in-law. My nephew doesn't remember his father much because he was 2 when this accident occurred. And I sold my house and I moved back to Ennis to raise my nephew and help look after my aging parents. The effects of this bill are devastating and wrong. My mental anguish is amplified. Actions by this foreign company and driver who is intoxicated, being on our Texas roads, it enrages me to this day. Mr. Birdwell, I wish you would change this bill and protect your voters and stop protecting these foreign trucking companies who are on our roads today. Thank you.
All right, thank you very much. Very sorry for your loss, sir.
Thank you.
Thank y'all for coming. You're excused.
Thank you.
Thank you. We'll call up the next panel. That's Drew Gibbs, Amy Bolding, Julie Zandra Cedino, and it looks like Lizandra Cedino. And for those in the audience who are wondering, the members are in other committees. This is all being recorded and video archived. The staff is all here taking notes for their members. And so y'all each heard the 2-minute. When you see the 2-minute, the yellow light, that's halfway through, and when you get to the red one, please stop. So we'll start with the ladies. We'll start on this end first. Please state your name for the record and your position on the bill.
Yes. My name is Amy Bolding. I live in Bernie, Texas, and I oppose Bill SB 39, House Bill 4688. On July 16, 2021, just 19 days after her 5th birthday, our daughter Sadie and her 8-year-old sister were driving with their grandparents through Blanco, Texas. They were coming back from a fun day in San Antonio when suddenly a 40-ton 18-wheeler crossed over the center line and crashed into the driver's side of their pickup. Sadie's door was ripped off, causing her to hang out of the vehicle by her seatbelt before assistance arrived. She was airlifted and had to be revived multiple times on her way to the trauma hospital. When we arrived at the hospital, we were told she would likely not make it, and her beloved grandfather also nearly lost his life. The driver of the 18-wheeler told the investigating officer that he had no idea why he crashed into the pickup. Evidently, he was so focused on a cell phone conversation he was having that he unknowingly plowed into my family that was across the road. The conduct of the driver that day was dangerous, it was reckless, and it was also preventable. The responsibility for Sadie's injuries falls at large on the parent company of the driver, as it knew the dangers of driving while using a cell phone, but it did not have safety policies in place that restricted such behavior. Sadie suffered extensive injuries and surgeries as outlined in the handouts received. She has significant scarring all over her body. She has experienced immense amounts of pain, and Sadie will likely not graduate from high school or be able to have gainful employment or have a normal life. Please don't take away a victim's right to hold a trucking company responsible for failing to have safety policies that protect the public. Please preserve a victim's right to have a jury consider all of a victim's damages. Thank you.
Thank you very much. I'm so sorry.
Thank you.
Just please state your name for the record. Pull that mic over. Yeah, thank you.
Sorry.
Take your time.
Hi, my name is Julie Zandra, and I'm from San Antonio, Texas, and I oppose Senate Bill 39. My sister, Lysandro, is going to tell you a little bit more about my mom's accident, but I want to talk about how it's affected us personally. I'm the youngest of my mom's daughters. She has 3. I'm sorry. And I don't get to have her. I don't get to talk to her. She was my best friend. My sisters don't get to have her cheering on her in her corner. And we just really miss her, and it's really, really hard for us to go on with our life without her. And it's really, really hard. She was so important to us, and now we only have a memory of her. Currently, I have to plan a wedding without her, and it's really, really hard. We are really, really grateful that my mom is alive. But she's not who she used to be, and nobody warned us that. Nobody warned us she'd need all this care and taken care of, and that she would change and not know who we are or be mean. And it was just because a trucker hit her. And today, as you can see, to share my story is really not easy, and it's really, really painful. But I think the trucking companies need to be held accountable for the drivers that they put on the road, negligent or not. I just think that they need to be held accountable for the Texans drivers on the road. And that's all I'm going to say.
That's okay. Thank you. Please state your name.
My name is Lysandra Cedino, and I'm from Dallas, Texas. This is my sister, Julie. And I oppose Senate Bill 39. I passed out a summary of my mom's accident, just to kind of give an overview. She was driving on Highway 10, and she was hit from behind by an 18-wheeler. Due to the accident, she suffered a permanent brain damage, which caused her to be completely incapacitated, and she now has to live in a facility to get the care that she needs. She's unable to take care of herself, and she dependent on others to take care of her. Some things that were pointed out in the summary: 3 out of the 4 brakes of the truck trailer were out of spec, and the driver was on the phone for over 5 hours, almost 6 hours of the total 6.5-hour drive that he was on that day of the accident. Just the lack of safety measures of the trucking company that they put on their employees and also on the equipment is just where it just caused my mom to be where she is today. Before the accident, my mom had a really beautiful life. She was the definition of a proud, successful woman, and she was the role model to not just us, but just the people around her. She was a true pillar of the community, and she would be very proud of us for here advocating for her. She would be here too if she could. But now she lives, because of her injury, she has to suffer just constant anxiety, constant stress, and constant pain, and she's just living a life that she would never, ever want to live in. And it's unfortunate that she lives in this nightmare that she can't wake up from. Her medical care alone will cost, she is planning to live a life, but she will need medical care that will cost $17 million. And the trucking company's insurance policy was only $1 million. So we do not want to change laws that hold trucking companies less accountable, especially for the damages caused to Texas drivers. Thank you.
Thank you very much. Drew?
My name is Drew Gibbs. I'm a conservative Republican, former insurance defense attorney, and current plaintiff's trial lawyer, owner of Slingshot Law Injury Attorneys. I'm here to testify against Senate Bill 39, and I will talk about what occurred on March 13th, a travesty in this community. And I'm not just talking about the filing of Senate Bill 39. I'm talking about the 5 Texans that were killed on I-35 at Palmer Lane. You've heard a little bit about that collision. I want to clarify. I provided you a handout. I want to talk about the first phase of the trial under this bill is not just about assessing damages, it's about assessing negligence. And what occurred that day is not just the negligence of Solomon Walkadil Araya, an Ethiopian who had a driver's license for less than 4 months when he killed those 5 people. It's also about the negligence of ZBN Transport, who hired him, and Amazon, who hired him to drive that 18-wheeler. He was not qualified to be behind the road because he didn't speak English. The handout that I gave you gives a video. The first page is a link to a video taken at the scene. You can assess for yourself. Did he speak English or not? State and federal law requires that commercial drivers speak English, and it's important that they do, not because we're racist or xenophobic, but because they need to read signs. Signs like one that's pictured on that handout. That one says, "The eyes of Texas are upon you," a cutesy sign that we put up during Texas OU weekend. But the sign that Mr. Araya drove past that night is one that would have said something like, "Road construction ahead. Traffic stopped ahead." You watch that video, please, and decide for yourself. Could he actually read that sign? He should never have been hired. And when that first phase of that trial occurs, we should know that he should never have been hired by that company. The second thing that's on that page is the arrest affidavit. He was arrested for intoxication manslaughter, something that should be clarified. I don't know why I have 2 seconds left. That's not correct. Something that should be clarified is that he was arrested for intoxication manslaughter. He tested negative for drugs and alcohol. He was fatigued.
Thank you very much. Your time's up. I appreciate it. Very sorry for y'all's loss, really am. Good luck with your mom.
Thank you.
All right, thank you. We'll call up the next panel. Jody Scott, Marie Annette Navarrete, Pontiac, Michigan. Okay. Jessica Sprague and Jason Sprague. Go ahead, please pull the mic over to you. State your name for the record and your position on the bill. I'm missing one on the panel. I had a Jessica Sprague, a Jason Sprague. Somebody still coming? Well, go ahead.
My name is Maria Navarrete. I am originally from Pasadena, Texas, and I oppose Senate Bill 39. On August 5th, 2022, my life, my physical and mental well-being was changed forever. I have lost the ability to enjoy life fully before, as well as lost the ability to be a provider for myself, as I have worked since I was 16 years old. I was violently T-boned by a reckless, distracted driver that had a newborn baby and his wife in his cab when he missed the red flashing stop sign, causing my Toyota Civic to bounce down the side of the 18-wheeler truck, completely smashing my car. At one point, I was airborne, on my whole body lifted up from the driver's seat, and I just screamed, "Jesus, help me." I felt the glass all over my face and arms and felt the impact of the airbags. The next moment I remember is a father seeing Tom pulling me out of the car and people yelling that there was gas leaking. By the mercy of God, I am alive. To date, I've endured 5 surgeries on my upper and lower back, both knees and one in my hand. That is not including the pain management intervention with blocks on my back for the discs that were completely out of place. Today, I struggle with daily pain and struggle with driving a car due to PTSD. I can no longer work to provide for myself and was eventually put on disability, full disability due to my injuries. I am thankful for our current law allowing me to hold this person and company responsible for my life-altering changes. Changing this law would ensure that my rights or a hurt individual's rights would greatly be diminished, causing more harm. I pray for your compassion.
Thank you very much. I'm very sorry for your situation. You must be Jessica. State your name, please.
Good morning. My name is Jessica Sprague, and this is my husband, Jason. This is our son, Colton. We are from Houston, Texas, and we oppose Senate Bill 39 because Colton was killed when a truck driver ran a stop sign and T-boned our vehicle. That truck driver had a history of drug use and never should have been behind the wheel that day. July 24th, 2022 was the worst day of our lives. That was the day we lost Colton. I remember my husband screaming Colton's name as he tried to save him. It felt like an eternity at the hospital. As the doctors worked on him, he was going to be life-flighted to another hospital, but his vitals crashed. We watched him get carted to and from the helicopter. Eventually, Colton had been given as much medicine as possible without it becoming toxic to him, and ultimately he passed at 2:02 that afternoon. He was 16 months old. Through our case, we learned the following. while we were trying to save Colton, the truck driver received text messages from his wife about getting urine for his post-accident drug test. The driver beat his drug test because the company allowed him to go home and provide it the next day. And the driver was fired from his last employer for refusing a drug test. But the company still hired him because they did not follow the regulations for investigating the driver's background. These horrific facts paint a stark picture of just how tragic yet preventable our son's death was. This bill would have prevented a jury from knowing why we really lost our son. They would have only heard about a man who ran a stop sign. This crash was not just about a man who ran a stop sign. It was about a company who never should have employed that man in the first place. If a company can hide from that truth, they won't get any safer. On the 2-year anniversary of the crash, we welcomed a baby girl. She will never get to meet her brother here on Earth, and we will never know the amazing big brother Colton would have been. Thank you.
Thank you.
My name is Jason Sprague. I'm Colton's dad. And I oppose Senate Bill 39. When I don't have anything written out, but just being here today and listening to the people that were up here and talking about insurance prices, and then they leave the room whenever the real victims are coming up. And I know that we have representatives here and people here taking notes, but whenever the rest of the people also leave the room, whenever we're telling the real world stories, that does not make me feel like our voices are being heard. Thank you.
Thank you. Very sorry for your son's loss. You must be
Good morning.
Jody?
My name is Jody Scott, and I'm here with my daughter, Aubrey Scott, who is 13. I have lots written down, but I'm not quite sure I can get through all of it. Back in September of 2015, my husband lost his life. A trucker ran into my husband's Camaro, who was behind a gas tanker truck, and they were stopped to let a school bus release kids on the opposite side of the road. This truck driver with CKJ Trucking did not see everyone stopped for the school bus and ran right into the back of his Camaro, and he was killed instantly. This trucker should not have been employed. I don't know if I'm going to get through this.
Take your time, take a deep breath.
CKJ CEO Jonathan Cranmar was chairman of the Texas Trucking Alliance in 2021. When this original bill was passed, Jonathan Cranmar, the CEO that was responsible for my husband Donnie's death, has led the charge for this bill, which shields their bad conduct for injuries and prevents true accountability. This bill raises significant concerns about the safety of our communities. It seems to allow dangerous companies such as CKJ to invade responsibility for the tragic consequences of their actions that can have on us Texans. If passed, it could prevent us from fully understanding how unsafe practices lead to accidents that devastate families and harm our communities and our roads. Thank you.
Thank you. Very sorry. Thank you all for being here.
Thank you.
Call up Robert McCart, Bradley Pearson, Melissa Traylor, and Autumn Owen. Sir, you were first. Go ahead and please state your name for the record and your position.
I'm Bradley Pearson. My wife Leslie's with me today. 9 days ago was the 5th anniversary that we lost our 28-year-old only son. It was the worst day of our lives. He was on his way to our house to visit us when a cement truck driver turned left in front of him, hitting him head on and killing him instantly. He was on the cell phone. He was also a convicted felon. Our attorney found out he'd been on the phone 55 minutes when he hit our son. He claimed he'd never saw our son, which is textbook inattention blindness. They proved his cell phone talking was habitual. They overlapped his cell records with his driving logs, and him and a fellow driver, which both knew it was against company policy, in the previous 90 days had had 150-plus phone calls between the two drivers. Burnco admitted they didn't enforce their no cell phone policy. Our son could still be alive today had they enforced their policies. We're very close. My wife became suicidal after that. Luckily, with treatment, she got through it. Parents aren't supposed to bury a child. This bill prevents jurors from getting full story of how the dangerous actions and unsafe employers like Burnco cause the death and mayhem on our roads and destroy families in the initial phase of this. If passed by you, this bill will allow dangerous companies that don't enforce their own safety rules to escape full responsibility for killing and injuring Texas. It puts all of us in danger. This could happen to any of us on the way home today. Nobody's safe. So thank you for your time.
Thank you. Sir, please state your name for the record.
I'm Robert McCart, speaking against Senate Bill 39. I'm not going to bore you with the long, tragic story of my wife and how our lives have changed. I'm not going to bore you with the long history of this driver who should have never been on the road. I'm kind of a simpleton. I fail to understand how a bill that puts up another wall in the legal process that I have to climb protects and serves me, the rest of these folks, the state of Texas. This bill is designed to protect insurance companies and trucking companies. I believe a gentleman over here earlier today said the insurance company never loses. The idea that this is going to lower our rate or make our life better, non-existent. Do what is right. Do the right thing for your citizen, for your constituent, and for the people in this room. Thank you.
Thank you, sir. Please state your name, ma'am. No outburst,
Good
please.
morning, and thank you for the opportunity to speak before you today. My name is Melissa Traylor. I'm the widow of Officer Andy Traylor. I am in opposition of Senate Bill 39. Andy and I met in 2003 while he was in the Navy, where he served honorably 10 years as a submariner. We had 3 beautiful kids in that time. After his time served, we moved to the great state of Texas, where he ultimately pursued his dream of becoming a police officer for the city of Austin. On July 13th, 2012, he was sworn in as a peace officer. To Andy, this wasn't just a job, but a calling. He was born for this position. After just a few short years in the department, we got our license to become foster parents and fostered 13 babies and adopting 2 of them. On July 28, 2021, at around 2 a.m., a Cisco truck driver pulling a trailer was traveling along FM 969 when he saw the railroad crossing lights flashing up ahead. Impatiently, he did not want to wait for the train, so he chose to make an illegal and unsafe U-turn. At that same time, my husband, who was working overtime that night, was headed down the same dark road on his way to a shots fired call. Little did he know, his demise was waiting for him just a short distance ahead. Andy had traveled this strip of road hundreds, if not thousands of times, but that night would be different. It was at 2:09 that the 18-wheeler was blocking all 4 lanes of traffic, leaving Andy no time to see the truck in front of him or to react. Even if he could, there was nowhere for him to go, since the truck was impeding all lanes of traffic. Andy's patrol car slammed into the side of the trailer, causing it to come lodged. In that moment, my past, present, and future were taken from me. The kids and I never thought sending him off that night would be the last, and we would see him alive. Andy was only 37 years young. He was just starting his life. He was the sole provider for our family of 7 and a devout husband and an incredible father, an impeccable cop. Because of Andy's job, I was able to do what I loved most, which was staying at home.
Thank you. You're Autumn.
Yes.
Please state your name for the record.
Good morning. My name is Autumn Owen. I am a defense attorney
and I operate primarily in trucking accidents, and I am in support of Senate Bill 39. I first off want to say I sympathize with all of the testimony that you've heard today about these horrendous accidents. However, what we're here to talk about is the bifurcated trial and whether the current structure is appropriate. The intention of House Bill 19 was to have the bifurcated trial so that the cause of an accident as well as the compensatory damages were decided in the first phase. Everything after that, what was intended to punish the driver, the trucking company, that is for the second phase. It goes exactly with what Senator Perry had mentioned about how we handle it in our criminal system. In order for individuals to get a fair system, they need to have a fair shot. What is important in the first phase is what caused the accident, not the ability for plaintiffs' counsels to have smoke and mirror showing that some ticky-tack, they didn't file some kind of application when they started employment, negates the fact that their client may have ran a red light. And I'm not saying that that's the stories of these individuals. The issue here is that currently, as it is written, the statute allows plaintiffs' counsels to attack not just these $80,000 or 80,000 truck companies, as you heard earlier. My clients are not these Middle Easterns in the basement. They are small trucking companies, and they are getting hit with the exact same negligent entrustment claims as these huge companies and getting nailed to the cross for essentially having a company and trying to do their best when we've already admitted that our driver was in the course and scope, we've already admitted fault, and we just want to pay what's fair and reasonable. It prejudices my client, it's not fair, and as the bill is currently written, it would make this a fair trial.
Senator West, I think, wants to ask the
At
question.
all due respect, I've practiced a little law in my time, and juries can take into consideration in criminal cases what's been introduced during the case in chief, during the regular case, and also take that into consideration during the punishment phase. So whatever evidence is admissible during the first phase of the trial can be considered also by the jury in the second phase of the trial to determine what the punishment should be.
It's certainly possible, however.
It's not possible, it is. They can do it.
Well, and respectfully, Senator, what we're seeing is we are seeing the unprejudicial effect that it has on clients. I'm sorry, the prejudicial effect that it has on trucking companies to have this information presented when it's intended to be a bifurcated trial.
No, I understand what you're saying, but to make a statement that it cannot be considered or should not be considered in criminal, you referred to my colleague Senator Perry. I didn't say anything to him because I just wanted to move it forward, but I can't let it continue to move forward without addressing it. And what I'm saying is that in criminal cases, a jury during punishment can take into consideration what was introduced during the case in chief. That's all I'm saying.
Understood.
All right. Thank all of y'all for coming. Very sorry for your situations. Call up Ronald Bear from Montgomery, Texas. Victoria looks like Lemon from Buda. Gary Spring from Austin. And this one's a little hard. Ty Turkett from Valley Mills. Go ahead and state your name for the record, sir. And
Ron Bear.
Go ahead.
Your Honor, my name is Ron Bear. I've been a litigator for 43 years. My specialty is in trucking litigation. I want to speak in favor of eliminating the evidence on the issue of negligent entrustment in phase one of the trial. The objective of the statute is to simplify the core decision that has to be made in a trucking accident, which is of the two drivers that are involved, who caused or contributed to the accident, and in what percentages. If you go beyond that inquiry and you start bringing in evidence of negligent entrustment, it's like trying to put a square peg in a round hole. It's going to confuse, muddy the water with respect to the consideration of the fault of the two drivers. The jury just simply needs to determine who caused the accident as a result of the conduct of the two drivers, not any evidence that comes in with regard to negligent entrustment. Now, having litigated hundreds, if not thousands, of these trucking cases, in my opinion, the only reason plaintiff's counsel would want to admit evidence of negligent entrustment in phase one of the trial would be an attempt to demonize the trucking company and then hope that that would have a carryover effect when the jury has deliberation with regard to the fault of the drivers, and that would not be appropriate in terms of trying to have a just and fair trial. That would interfere, in fact, with the core intent of our judicial system, which is to have a verdict decided directly and simply on the facts of the case. There's no harm to the plaintiff without negligent entrustment evidence in phase one. The percentages of fault will still be decided and applied to the damage findings, resulting in a judgment reached with a fair consideration
Okay.
of the evidence.
You want to ask a question?
I do, and thank you very much for your testimony and your experience in this area.
Yes, sir.
I haven't tried any cases in this area. As it relates to a hypothetical that was given by earlier,
Yes, sir.
if a driver is driving a truck, did not load the truck, but it was loaded by the owner of the company under their directions,
Yes, sir.
and they run into overpass, no negligence on their part, the driver's doing what they're supposed to do. How do you then make certain that the jury knows that, as it relates to apportioning liability, comparative negligence, that you would ding, if you will, the driver of that truck, when in fact it's actually the company that loaded the truck? How does that work out?
Well, I'm glad you asked that question. There's actually two parts to that answer. The first part of the answer is that, according to Lee, that evidence would still come in with regard to the cause of the accident. The second part of
Is that
that
a
is,
separate cause of action against the company?
yes,
Okay, go ahead.
in the first phase. But the second part of that is that a driver has a responsibility to do a pre-trip inspection of his truck and be knowledgeable about the route upon which he's going to travel. So that evidence would come in and should rightfully be considered then with respect to the fault of that particular trucking company driver.
And also the independent cause of action as it relates to the failure to load the truck right and all that other stuff against the company would also come in the first phase of the trial?
That's my understanding from the testimony this morning, and it's
Based on
important to.
based on your experience.
Oh, absolutely. And also, you need to put into perspective the negligent entrustment part of this consideration. It truly is putting a square peg in a round hole, because you're bringing up issues with regard to the trucking company's responsibilities with regard to how to properly, vet a driver for driving. When that happens, typically, in my 43 years of experience, the plaintiff's lawyers want to, and I can't fault them for trying, expand the scope of that inquiry to not just the driver involved in the accident, but other drivers of the trucking company. And it just keeps getting bigger and bigger. You back up the truck, you load that into phase one, pretty soon the jury's confused as to exactly what their job is, which is to say, who caused this accident? Not issues with regard to negligent entrustment.
Thank you, Mr. Chairman.
Thank you.
Thank you. Please, sir, state your name for the record.
My name's Gary Spring from Austin, Texas. I oppose this bill, Senate Bill 39. I'm here today because I lost my baby boy in a trucking accident. Let me just share with you some of the facts about that case. The driver was a 69-year-old man coming off of cancer treatment who had no trailer experience. Have no problem with that. The driver was never road tested by the trucking company. He'd never been given a road test even. At the time of the accident, the corporate office of the trucking company was on the phone with the driver, telling him to come across the street to get his check on Friday instead of turning right and going and delivering his load. At the accident, DPS told the owner of the trucking company to take the truck directly across the street and park it and secure it, because there's evidence there. There was a dash cam, everything. The truck was taken across to the lot, and was it secured? No, the dash cam was immediately removed. Lo and behold, I mean, we had to go through all kind of court proceedings to even get them to acknowledge that there was a dash cam. And by the time we got it, the dash cam was professionally deleted. Luckily, we had other video evidence from the scene from a store that gave us insight into what actually happened. But that's just one example of what you're dealing with out there. And this bill, I oppose it, and I hope you all will too.
Thank you, sir. Please, ma'am. If you want to pull that mic over to you.
My name is Victoria Limon, and I oppose Senate Bill 39. I'm from Buda, Texas. On March 22nd, 2024, that day is the day the earth stood still for me and my family. I was a special education teacher coming back on a field trip with 44 pre-K students, 4 and 5-year-olds, which included some of our deaf education students and some of our special education students. My daughter, Deanna Eve, was also on the bus with her pre-K class. As we were driving down the road, I was staring out the window and I saw this truck coming towards our lane. I kept thinking, surely he's gonna correct, he's gonna notice, but he never noticed. I could see the truck getting closer and all I could think about was just bracing for the impact. I closed my eyes and I held my daughter really tight and I could just hear the smashing of the metal. Our bus flipped. We hit every single side of the bus. Glass cut my body, cut my daughter's body. I fractured my back in 4 different places. When the bus stopped, all those kids who had fallen asleep on the bus were screaming, crying, blood pouring off their face. They had no idea what happened. You cannot unhear those screams. You cannot unsee the fear in their faces. They just wanted their mom so bad. Ulysses Rodriguez Montoya, one of our students, was laid lifeless on the ground. He never had a chance. He never made it home. His mommy never got a chance to hug him, ever again. If the trucking company had only done its due diligence, if the trucking company only, I know I'm out of time, please. If the trucking company only did its due diligence and knew to do a background check, knew to make sure that his driver was not on drugs that day. The driver admitted to being on drugs. The driver admitted to doing cocaine and drinking that day. This is not smoke and mirrors. The trucking company tossed this driver the keys. A driver who is unsuitable to be on the road, and those kids are forever scarred. 44 kids at 4 years old are going to wake up one day and realize, holy cow, that wasn't a dream. That was my life.
Yeah, thank you. That's a terrible story.
Terrible.
Thank you. Yeah.
Terrible.
Please pull the mic around. Very sorry.
My name's Ty Turkett. I live in Valley Mills, Texas. On September 22nd of 2023, my 19-year-old, 7.5-month pregnant daughter was advised to go get her teeth cleaned just down the road. Her mother wanted to go with her, so me and her mother were at the entrance of the ranch waiting for her. She slowly come to a stop there in front of us and was 60 feet from us, looking out the driver's side window right at us. All of a sudden, 80,000-pound semi-truck pulling pipe heading to Midland, Texas, appeared behind the oak tree. He had 10 seconds to stop that truck. The sun was at his back. Jesse James couldn't have asked for anything more. He had clear line of sight. He didn't hit her. He ran over her. Me and her mother were the first ones to the car. I went to bed last night looking at my daughter, looking at me out the window. She never even seen what was coming. Small town truckers are just a name on the door. They're not truckers. After everything that I've learned, the case is ongoing. There were visuals that should have been caught when he was loaded. There were online signs that should have been caught by the brokers. There were multiple things. It's almost, me and her mother I pulled her out of the car, laid her on the asphalt, and started resuscitation until some help got there and care lift got there. She was care lifted to Baylor, Scott, and White in Waco, and they did an emergency C-section. She passed away 3 days after the accident. The baby survived, but she has damage. The umbilical cord went acidyne because Emily had died on the scene, and the baby has severe brain damage. So we've been living in severe damage or catastrophic for 18 months now. It's only going to get worse on these highways, and I oppose Senate Bill 39, and I oppose Senate Bill 30.
All right, sir.
Thank you.
Thank you. And thank all of y'all for coming. We really appreciate you being here.
Oh, can I show you a picture?
You can leave a picture with her, and she'll share it with us.
That's 3 days before the accident.
All right, thank you, sir. Call up Lori Villa, Edinburgh. Laura Tenez, Texas Trial Lawyers. Ashley Sibley. And Ashley looked like Mulkey, M-U-L-K-E-Y, from, looks like Alton? Looks like Louisiana. Anyway, that's 4 called up, so you're first, ma'am, so please go ahead and state your name for the record.
Yes, my name is Laura Tamez. I am former president of the Texas Trial Lawyers Association. I was vice president of legislative affairs in 2021 and was part of the stakeholder conversations back at that time. I want to clarify for this committee something that TLR represented, and that is that the admission, and I'm here to testify opposed to the bill, that TLR indicated that the admissions rule is the law in Texas. That the admissions rule has been the law since 1961. Well, the admissions rule that was talked about in 1961 is a Court of Appeals case out of Beaumont, Texas. It was not the Texas Supreme Court who dictates what the law is. Prior to this bill being enacted, 2021 in Chapter 72, the law was what this legislative body mandated, which is we are now a Chapter 33 state. 30 states in the nation have some portion of comparative responsibility where any entity, any person who caused or contributed to the cause of the crash will be adjudicated by a civil jury. So all of the evidence that could have caused the crash, for example, if a trucking company knows that there is a driver who has 5 DWIs in their history, true story, that has 3 convictions for reckless driving and speeding, that has failed toxicology screens repeatedly. Those are the bad choices that a company makes, aside from the negligent loading. But the choices they make the day before the crash, months before the crash, years before the crash, that specifically govern the crash or cause the crash should be adjudicated by the jury. Our mandate was to protect good companies and punish the bad companies. But stripping out the exceptions to the rule, you lose the guardrails, guidelines, and framework for the judiciary. Okay. And yes,
I have to ask
thank you.
So please, Senator West.
Laura, thank you very much for your testimony. How many appellate or Supreme Court cases have there been since 9/1/21 when this law took effect?
None. There has been a first Court of Appeals case, and I'm a practitioner and have been for 30 years, and I've tried one of these cases under the new law of Chapter 72, and have gone around the state with defense lawyers so that we can present how to try a case under Chapter 72. The only case currently is a first Court of Appeals case where the judge went outside of the code and may have been looking at the conflict of authority that had existed before this statute was enacted. That took away the conflict of authority, but the judge did not read the code in the manner it was written. First Court of Appeals told the judge, You have abused your discretion, and that case needs to go back to the trial court. So it is working. Good trial lawyers are able to litigate these cases both on the defense side, both on the plaintiff side, because the guidelines give the judges no discretion on how to try the case, when the trunking company is going to be in on the line. But the exceptions being pulled out of that, the judge now loses those guidelines and guardrails, and good companies may have to be forced to the gross negligence phase.
Thank you very much.
Thank you. So we'll go ahead and please state your name for the record, ma'am.
My name is Lori Valda. I'm from Edinburgh, Texas, and I'm here to strongly oppose Senate Bill 39. On December 29, 2022, my husband David was killed in a crash that should have never happened. A truck driver pulling an extended gooseneck trailer made a reckless left turn in front of him. The trailer had no lights, a reflective tape that was damaged, nothing that would make it visible to oncoming traffic. It was being driven after dark with no escort and by someone who had never been properly trained by his company. My husband didn't have a chance to react, and in a moment, he was gone. That night, I was waiting for him to call and tell me that he had made it back to his hotel. But instead, I got a call from someone telling me he was involved in a car accident and he didn't make it. My kids were standing around me wondering why I wouldn't stop screaming, but that's all I could do. And that moment changed our lives forever. I became a widow, and our 4 children lost their father. My daughter spent her senior year of high school grieving, and my baby, who was just 1, still asked if her daddy is coming home. My 2 boys, they still needed their dad. He was supposed to teach them, guide them, play football, take them fishing, and now they have to grow up without him. Because of the laws we have in Texas today, I was able to hold that company accountable. Those laws gave me access to the truth that the driver had been operating dangerously for a long time, and that the company did nothing to stop it. A year after killing my husband, that same driver caused another crash in the exact same way. If these bills pass, families like mine will be silenced. The truth will be hidden, and these bills protect companies that fail to train their drivers, ignore safety, and put profits above human rights, human lives. Please don't take that away from others, and don't silence families like mine.
Thank you very much. Either one of y'all.
We have handouts as well.
Okay. Please pull the mic over and state your name for the record.
I'm Ashley Hamby-Mulkey, and I'm here to speak against Senate Bill 39. We are against this bill because families seeking justice need to hear need the jury to hear all the facts when deciding who is at fault, not just the facts the company wants the jury to hear. If the trucking company that killed our husbands had tested for drugs or audited logs, we wouldn't be here. This bill would take away the right of victims to hold companies accountable for not following the law. Don't worry, Ellie, Daddy's always come home. That is a direct quote from my 3-year-old daughter, Millie, on December 11th, 2021. Early that morning, my husband, Caleb Hamby, and my cousin, Corey Webb, were killed tragically in a motor vehicle collision involving 2 18-wheelers. It was ruled negligent vehicular homicide. Unless you have lost a spouse, you can only imagine the horror we went through on that day. As hard as it was to lose our husbands, it was pure torture to watch our children lose their daddies. Through our own deep grief that day, we had to sit down our 6 babies, ages 6 and under, and tell them their daddies were killed. It was only a few minutes after this that my daughter Millie noticed Corey's daughter Ellie crying. She gave her a hug and gently cupped Ellie's cheeks with her tiny hands and uttered the most innocent words I've ever heard. "Don't worry, Ellie, Daddy's always come home." You see, they had never known a world in which their daddies didn't come home, and it shattered my heart to a million pieces to correct my daughter and tell her, this time Daddy isn't coming home.
Thank
you. My name is Ashley Webb Sibley, and I'm against SB 39. As you can see from the handouts we gave you, the driver that killed our husbands was under the influence of drugs and over his hours. And this ultimately led to him falling asleep at the wheel. Our husbands were doing nothing wrong. They were at a complete stop, waiting for another 18-wheeler ahead of them to make a left turn when they were hit by this driver. at 69 miles per hour on cruise control, and never hitting the brakes and killing them instantly. What we could never do in under 2 minutes is explain to you how much these men meant to us and to the world. They weren't only husbands and fathers, but they were sons, brothers, cousins, friends, and so much more. Their loss affected every person that knew them and loved them, and we will do everything in our power to help minimize these tragic, unnecessary losses due to negligence. This starts with accountability. Taking away accountability will only lead to more negligence and more stories just like ours, with more children being told that he isn't coming home. Also, silencing victims and not allowing their full stories to be told in complete truth is unfair and unjust. When you consider this bill, I urge you to think of us and our children, and remember that the safety of our own family and friends is at stake. We respectfully request Texas to reject SB 39 and HB 4688 and support victims like our families.
Thank you very much. Very sorry. Thank you all for coming. I'll call up the next panel, Lauren Robinson, Dale Robinson, Whitesboro. Looks like Robinson. It's your writing. Robin, S-A-B, or Robinson. Whitesboro. That's Robinson. Enri Contreras from Northlake. You were first, sir. Go ahead and pull the mic over. State your name and your position on the bill.
I am Doc Robinson, and I'm against the bill. I have a unique situation. I own an excavation company, and we had commercial trucks. As a company owner, we only hired drivers with a good safety record, drivers that had a 2-year medical card, did everything that we could to make sure people we had on the road were always safe. And I feel like if we could do that as a small operation, everyone else can do the same. April 5th, 2021, I lost my brother and niece due to a commercial driver. He was driving a trash truck. Driver fell asleep, crashed into an onslaught of cars that were parked behind the school bus. And April 6th, just personally, I went to go to where, they have the coroners down there in Dallas. And I went to go pick up my brother, Casey Robinson, my niece, Brindley Robinson, 6 years old. My brother was a Salina police detective. So I went down there with his brothers and sisters in law enforcement, and I personally brought him back. But seeing firsthand what commercial vehicles can do, it made me, I guess, more confident in my decision, being extremely picky on how we hired drivers in our situation. That's all I got.
All right, thank you.
My name is Lauren Robinson. I'm from Whitesboro, Texas, and I oppose Senate Bill 39. As Doc was talking, on April 5th, 2021, the worst day of my life, 4 years ago as of Saturday, my family and I were involved in a trucking accident. We were rear-ended by a fully loaded trash truck going 67 miles per hour as we were at a standstill behind 3 other vehicles that were behind a school bus full of kids unloading them. My husband, Casey, of 15 years, and my 6-year-old daughter, Brindley, were killed instantly, and I was critically injured. I was care-flighted, and I spent 8 days in the hospital. He was a Salina police officer, and that was his passion, and it would just literally kill him to know the standards of the trucking company when he was one of those that made sure that they did what they were supposed to do. I had 3 months of physical therapy, and at this point, I still have medical issues 4 years later. I had a traumatic brain injury. I'm no longer able to work. I lost the love of my life. I lost my future, my daughter. I'm an orphan myself, and so I have no immediate family. Because of what happened on April 5th, I'll never be the same. It's changed my life. I would not wish this on my worst enemy. My livelihood has changed. I can tell you Texas needs safe roads, and if this bill passes, it would make it harder to hold trucking companies responsible when their negligence leads to serious accidents like the one I was in. Ultimately, if this bill passes, it would limit justice for victims of trucking accidents like myself. I feel this bill actually lowers standards for trucking companies when in fact, I feel like the standards should actually be higher than they are now.
Thank you very much. I'm very sorry. Sir, please go ahead. Sir, please state your name.
My name is Dale Robinson. I'm against this bill. Casey was my son. Bradley was my granddaughter. As I started our company nearly 50 years ago with integrity and honesty and reliability to be taking account for everything we did. And as my son stated, we sold those trucks within a year and a half after this accident because I don't want to be putting anyone else in this position. The grief is real, the devastation is real, the finances. As my daughter-in-law told you, you don't lose one income, you lose two. They were just in their new home for 4 months. How do you survive this when you take away victims' rights? Only thing I could tell you, all of you need to think about God and responsibility to be doing the best judgment that you can for everyone. And that's all.
Thank you, sir. I'm so sorry. Emery,
Yes, sir.
please state your name.
Good morning. My name is Emery Contreras, the daughter of Tiffany Luann Jared, who was killed by an 18-wheeler on the morning of February 11th, 2021, in the I-35 car pileup, also known as the worst car pileup in Fort Worth, Texas. And today I have written a poem to oppose Senate Bill 39. When the birds fly and the bees buzz, I still think of you. On those subtle, calming evenings, I still think of you. When the nights are long and my room is dark, I still think of you. Point is, it doesn't matter where I'm at or what the clock may say, I still think of you. Every corner of my house is haunted from the joy you once spread, from laughs to tears you have now brought us throughout the years. You're like a blinding angel that I can't see. I mourn you every morning even though you stay with me. I never thought I could miss someone this much, but now that you're gone, I feel the hunch. You can't hold me when I'm alone. It's like my heart has been ripped from me and then thrown. Torn from my body and disposed ruthlessly. Oh, I wish people could understand that grief stabs you brutally. You'll never come back, and I understand that now, but back then I couldn't comprehend how this could be allowed. Now you can see what this pain has inflicted on me. From ashes to dust and sadness to sorrow, there has been no change. This wound is still open, my emotions unspoken. Her death has taken a toll on me. With emotions like these, I beg you please vote against Senate Bill 39.
Thank you. Thank all of y'all for coming. Very sorry. Very well. Call up the next panel. Cynthia Gear, North Lake. Nicole Mackledorf, Navasota. Jordan Monk, Baytown. And Tricia Graham, Nevada, Texas. And so, ma'am, if you'll go ahead and pull that mic up to you and state your name for the record. And begin your testimony.
Good morning. My name is Cindy Jared. I am here today with my husband, Juan, and our granddaughter, Emery. We are from North Lake, a small town north of Fort Worth, and we are here to oppose Senate Bill 39. On the morning of February the 11th of 21, while on her way to work at the Tarrant County Court, our beautiful 34-year-old daughter, Tiffany Jared, was killed when an inexperienced truck driver pulling a trailer for FedEx, carelessly plowed into her car. Not only was the driver not using caution on the icy toll road when he slammed into Tiffany, he was driving so fast that the truck and the trailer ran over the top of her car, killing her on impact. As a mother, it crushes my heart to know that Tiffany did not have time to escape the car, and I could feel the fear and the helplessness that she must have experienced in her final few seconds as she looked back into her rearview mirror and saw the 18-wheeler coming straight at her. We were never able to say goodbye or to see her again or hold her hand or kiss her cheek. That was all taken from us by someone who failed to uphold the standards of training and safety protocols set by truck drivers. That morning, we lost our only daughter. Our 4 sons lost their sister. And at the young age of 11, Emery lost her mommy. That day in Fort Worth changed our lives forever. We long to see her beautiful smile again and to fill the void that she has left behind. Tiffany had the biggest personality and was full of life, and it was all taken from us in a matter of seconds. With the laws that are in place today, we are currently in the process of holding accountable not only the drivers, but the FedEx Corporation and all the trucking entities that have displayed substandard training for their employees, negligence, and the lack of upholding policy and safety. Our daughter's death changed our lives forever. Victims and their families should have the right to hold these companies accountable when their negligence causes death or catastrophic injuries to their loved ones.
All right, thank you, ma'am.
Thank you.
Are y'all all with her, or? Okay, all right, please go ahead and state your name, ma'am.
Hi, my name is Trisha Graham, and I oppose Senate Bill 39. I am the wife and now widow of Captain James Bull Graham, a beloved husband, father, and fire captain in McKinney, Texas. Jamie served this community for over 24 years, saving lives and protecting families. But in 2023, our lives were shattered when he was killed in McKinney by a reckless 18-wheeler driver with 21 prior driving violations. That driver should have never been on the road. Allow me to introduce to you a few very important people. First is our son, Jordan. He's in the middle here, who lost his dad in a completely preventable wreck. Jordan has followed his father's footsteps and became a firefighter just like his dad, and in so many ways being at the same station, McKinney Central Fire Station. Next, I have Captain Jack Poinkowski, who is also at McKinney Central Station. On this shift, Jamie would come in to relieve. He was with Jordan at Texas Task Force training the morning I had to call and let him know Daddy had been in an accident and wasn't expected to make it. Next, I have Taylor Crace and Chase Inman. They are firefighters at McKinney Central Station as well. They were 2 of the first responders on scene and had to use the jaws of life to pull Jamie, their coworker, friend, and captain they dearly loved, from his own vehicle. Finally, I have our youngest son, Jet, who also became a McKinney firefighter just 6 months ago. He is proudly following his daddy's and brother's footsteps. I'll never forget watching as he graduated McKinney Training Academy, surrounded by so many McKinney firefighters. The absence of Daddy was largely felt by everyone in the room. I stand here heartbroken, not just because I lost the love of my life, but because I see Senate Bill 30 as a betrayal to families like mine. Senate Bill 39 doesn't make Texas safer, it makes it more dangerous. I ask you, not as a politician, but as a fellow Texan, please don't turn your back on us. Please vote no on Senate Bill 39 and protect innocent Texas, not just those who put profit over people.
Thank you. She'll pass those out. Go ahead and state your name, ma'am.
Good morning. My name is Jordan Monk. I'm from Mont Belvieu, Texas, in Chambers County, and I am strongly opposed to Senate Bill 39. On July 6, 2024, I was a victim of a hit and run by an 18-wheeler. I was running errands that day, and I was on my way home, turning into my driveway. I live off of a farm-to-market road when I was hit from behind by an 18-wheeler going at least 55 miles an hour. This is all on video. My neighbor's Ring doorbell caught the whole thing, and the driver never stopped. My car was spun off of the road into a ditch, and I wake up and thank God every day that not only was my 10-year-old son not in the car with me, But that the angle that I was at allowed my car to be spun out and not run over or flipped. I'm very humbled by everyone's stories here today because I know mine could have been so much worse. But from my accident, I suffered a concussion that I am still experiencing vision loss from, headaches every day. I have 2 lumbar fractures. I have several herniated discs in both my cervical and lumbar spine, and I was recently advised by my orthopedic surgeon that the only surgical option I face at this point is a full lumbar fusion, which would severely diminish my quality of life, and I am only 32. My other option is an SI joint fusion, which would take away my ability to ever have children again. I live in pain every single day, and I am a single mom. And it is very, very difficult to wake up and go to work, but it's not an option for me. I have a person who depends on me and who is very active. There are no sick days for me and no time off. The man that hit me failed his initial drug screen for the company that hired him anyway, and they have 0 regulations in place, and this accident was 100% preventable.
Thank you.
Good morning. My name is Nicole McElduff, and I'm here for my son, Nathan Clark. He is my oldest son, and he's not here today. He isn't here today because my son was killed by an 18-wheeler driver. The driver was high. He was exhausted by driving for hours beyond his limit. The company never drug tested the driver. He never made sure that he was safe to be on the road. And they ignored a drug ring that was set up between the drivers. The name of the company was UPS. The driver and the company has changed me and my family's life forever. My son was only 25. I would never hear his voice. I would never see his face. His life was taken in a matter of minutes. He was rear-ended at 68 miles per hour. He had the cruise control on. And it could have been prevented. I will never have grandkids by him. He was just taken from me in a matter of minutes. I oppose Senate Bill 39. I just miss him so much.
Thank you. We feel for all of you, and I know it's really tough for y'all to come all the way up here, listen to all these stories, participate it. I can assure you there's a lot of people who are watching and listening to what you're saying, and it makes a difference, and I appreciate it very much. So thank y'all. I'm going to call up the next panel. Jessica Jenkins from Baytown, Joe Medina, Baytown, Dan Lineball from Houston, and Krista Spring from Austin. I'll be right back. You can stay, you can do that, Mike. I'll be back in 3 minutes.
Is he coming? I don't know. Is he coming back?
They're all leaving us.
Let's just start here at the far right, ma'am. State your name and your position for the bill. You have 2 minutes.
My name is Jessica Jenkins, and I oppose Senate Bill 39. On Father's Day weekend 2022, as my husband, Michael Jenkins, was coming home for lunch, a commercial vehicle ran a red light and struck his car. We were there on the scene in time to see first responders trying to resuscitate him. I was with my 18-month-old son, who still 3 years later remembers what he saw. The driver admitted to being high. The driver admitted to running the red light. Because of the current bills set in place, my legal representation was allowed to find all of the evidence in place. They knowingly put a driver behind the vehicle, in that vehicle, who had failed drug tests, had not been retested, and they did not have any safety procedures set in place for their company. I never involved an insurance company. That was off the table. All I asked was the ability to take care of my son, because no widow with a special needs child should ever have to choose between either feeding her son or providing for, or being a good mom to him. There's not a day that goes by that we don't live in the grief that we have been forced upon because of the negligence of a commercial vehicle driver. Please don't change this law. I strongly oppose this, because eliminating any accountability is hurting every single one of your constituents, because the next widow or widower could be yours.
Thank you, ma'am.
My name is Krista Spring, and I reside here in Austin, Texas. I oppose Senate Bill 39. My amazing son, Graylin Spring, was a freshman student athlete at Stephen F. Austin State University when killed by a commercial motor vehicle driver in Polk County in January of 2023. The 69-year-old driver of the truck had recently returned to work shortly after receiving cancer treatments, but his employer failed to road test him to see if he was medically able to drive. He also admitted that he could not see well, that he had cataracts. But again, his employer failed to test him. It was a Friday afternoon, and the truck driver was on his phone at the time of the impact with his employer because he was being told to come back to the shop because it was payday. After the crash, DPS officers told the driver and the owner of the company to take the truck back to the yard and lock it up to secure it. He took it back to the yard, but he took the dash cam out of the truck. And when that dash cam got back to the judge, it had been forensically wiped clean. No evidence now exists, which could have been very important in our case going forward. My son, Graylin Spring, was traveling to Houston to support members of the SFA track team and never made it. He deserves justice.
Thank you.
Thank you, ma'am.
Polk County.
Go ahead, sir.
Good morning. My name is Dan Linebaugh, and I'm an attorney from Baytown, Texas, and I oppose Senate Bill 39. A minute ago, you heard from Jesse Jenkins. Jesse's husband, Michael, was fatally injured in a commercial vehicle crash. Some of you may have known Michael. Michael had worked as an assistant to Mays Middleton when Mays was serving in the House. And it wasn't too long after that service that he was fatally injured in a crash, leaving behind Jessie and her son, PJ. You know, as an attorney, I see a cross-section of trucking cases. And what I've found is that the trucking companies that are the safe ones, that have good safety protocols and safety programs, they're not afraid of the truth. They'll put the truth out there. In fact, I want to read to y'all a section that comes from J.J. Keller, which is an industry leader in trucking. And here's a passage that talks about finding the answers to why the crash occurred. And here's a statement from one of their safety people. The theory of multiple causation says that there's more than one thing involved in causing an accident. Most people tend to look at one cause. This does not go far enough back to the root cause. And it goes on, it says, be prepared For many of these root causes wind back toward company management. Here's the point that even the safety folks know. It's not just about the driver at the intersection at that moment in time. It's about who trained him, what mistakes were made. It goes on and it says, we find that 90% of all accidents are caused by management. The employee may have made the driving error, but why did he make the error? It's about the root cause. And what's happening here is small trucking companies are trying to mask the truth. We've all heard it said, the whole truth and nothing but the truth. The jury needs to have the whole truth so they can have context and say what really caused this and assign appropriate percentages. Thank you.
Thank you, sir. Please state your, pull that mic over. Thank you. Please state your name for the record, sir.
My name is Joe Medina from Baytown, Texas, and I oppose the Senate bill. 7 years ago, my daughter was T-boned in a truck accident. But I don't want to talk about that. I want to talk about the truck driver or the truck company. He was a Cuban. He spoke no English. They ran this company out of an apartment complex. They had no kind of safety program. What they said in court was they looked at YouTube videos, and they had no records of anything that they had said. They said they did parking lot meetings before and after, and none of that was recorded. He never stopped at the light. There was a video showing where he ran it. All they kept saying was it was a simple mistake. His license, it took him like 3 times to pass it. It was in Florida. He was working for like a cousin or another guy from Cuba that just hired him on the spot. He didn't care what kind of safety or what kind of training he had. And I think if this passes, more stuff like this would just be happening, you know. That's all.
Thank all of you for coming. Very sorry. Thank you for coming here. We'll call up the next panel. Mike Lufkin, Brent Taylor from Dallas, Michael, looks like Lovins from Austin, Michael, Ware Wendell from Austin. So go ahead and start on this side, sir.
Good afternoon, folks. My name is Mike Love, Senator Nichols. I'm in your district. I work in Lufkin, Texas. I am an attorney, have been for 27 years. I practice 18-wheeler litigation. That's what I do. I've given dozens of CLE speeches to the state bar on both sides, defense, plaintiffs, both sides. And I want to tie something together for you to hopefully, I want you to have an epiphany moment here. The stories that you've heard today have one thing in common. I'm going to share with you what I said in one of the very first CLE speeches that I ever gave to both sides, defense and plaintiff. And that is, these professional truck drivers, they're skilled. They know what they're doing. They're highly technically skilled people, because you and I drive 10,000 miles a day. They drive a year. They drive 150,000 miles a year. They're good at what they do. So take any normal little crash together, 2 cars, a truck and a car come together, odds are it's the car's fault, not the professional driver. Because you and I can make a mistake just because we made a mistake. Michael Jordan doesn't miss a layup without there being a reason. And these professional truck drivers, the thing that comes in is if it turns out that it's the driver's fault, folks, there's almost always an underlying reason. And that's what you've heard today. Okay? There's almost always a systemic failure of the company to enforce safety rules, because these guys are good. They don't mess up for no reason. It's driving over hours. It's, pushing the load or not being trained, or it's some underlying problem that causes it. And this bill already is a problem because general negligence is like when you're doing everything wrong, it's just a matter of when, not if. And we're already limited in lots of ways, and this bill takes out the evidence for the rest of it.
All right, thank you. Please state your name, sir.
That's Mike Love. I'm Michael Lovins. I don't know how anybody planned that, but well done. I'm here in opposition to SB 39. I'm an active Republican. I'm a trial lawyer. I represent the Travis County Republican Party and several other conservative causes in litigation. I'm here to give a cold, emotionless defense of the free market. And this bill is precisely designed to damage the free market by creating a market failure. The elephant in the room today is that the purpose of this bill is to save big insurance companies money, and to do so by hiding important information from the jury. The tragic stories that we've been hearing today are instances of trucking companies creating extreme costs. Economists call them negative externalities, which doesn't sound very interesting. But it takes those costs and imposes them on others who didn't create them, the ones who are killed and maimed by these companies. A proper free market dictates that those who create the costs bear the costs. And this bill is precisely designed to create a market failure. And we talk about the phase 1 and phase 2 and all that stuff, but this is really about saving insurance companies money by allowing them to impose massive costs, death, maiming, and utter mayhem on people's lives, and they don't bear the full cost of that. This bill may be considered pro-business. It may be considered pro-insurance, but it's anti-individual. And as our representatives, your job is not to take the side of business or insurance or individuals. Proper conservatives take the side of the free market. And personal accountability, which is a fundamental tenet of conservatism, says that those who create the costs must bear the costs. This bill would do precisely the opposite of that, and that's why I urge you to defend the free market and oppose this bill. Thank you.
Sir. Please, go ahead.
Ware Wendell with Texas Watch against Senate Bill 39. For over 25 years, our nonpartisan nonprofit has advocated for safety and accountability in our state. You, as lawmakers, are being asked to contort the law for the second time in just a few years. And you're doing it in a state where large trucks kill and maim more citizens than anywhere else in the country. Anywhere else. This is federal data. Since at least 2017, Texas has ranked first in the country for the most large truck crashes. Since the bill was passed in 2021, the trucking industry has taken over 3,200 lives in Texas. They've injured over 45,000 Texans. When you put this in context, that's about double California, about triple Florida, other large states. There is a safety crisis on our roads. The problem with the legislation is there are no safety reforms in it at all. The complaints are about insurance premiums. There are no insurance reforms in the bill at all. We know that Texans across many lines, and y'all see me testify on this often, are suffering higher insurance rates. We need prior approval. But the industry, the property casualty industry, has been over-reserving. They've been hoarding cash. They've doubled their reserves since 2004 and jacking up our rates. So we need safety reforms. We need insurance reforms. We don't need more tort reforms. We've had 4 decades of it, and it's only helping the insurance companies, and it's only punishing the innocent. The jury deserves the whole truth, nothing but the truth. They deserve it up front. I ask you not to hide the ball. And Mr. Chairman, I will close on this. I have just a few seconds. I appreciate you being here throughout the entire hearing. Many of your colleagues were not able to hear from the families. It's been our privilege to work with many of the families today. I would ask you as a matter of honor to please share with them what you have heard, because it is the most heartbreaking testimony.
It's heartbreaking. Thank you.
Good afternoon. My name's Brent Taylor.
Turn the mic towards you.
I'm sorry. My name's Brent Taylor. I'm
There you go.
Secretary Treasurer and Business Manager of Teamsters Local Union 745 in Dallas. I'm also a Southern Region Vice President of our International out of Washington. I oppose SB 39. Me personally, I've driven trucks that we're talking about today. I've driven less than 10,000 pound, less than 20,000 pound, and I've driven the 80,000 pound trucks. And there is a lot that goes on when driving a truck. But what I'm hearing today, and I've sat in here since minute one, listening to all this testimony, we're talking about who's liable. We're talking about the driver, the company, the insurance company, and in my opinion, like one of my constituents down next to me said earlier, in my opinion, it's just a scam between big corp and insurance companies. That's all this is. Because I don't know how much you think a truck driver makes, but if a jury decides the company is not at fault or the insurance company has nothing to do with it, and a truck driver's making $60,000 a year, what do you think the victim's going to get out of that? Absolutely nothing. We're talking about deaths, people being maimed. So to hold a truck driver accountable for something like that, something that tragic, I think is not the right thing to do. Understand, a truck driver is the arm of the company when they're driving that piece of equipment. It's the company's piece of equipment. They're just an arm of the company. Give you, for instance, if you walk into a Costco and a forklift driver backs into you and breaks your ankle, who are you suing? Are you suing the forklift driver? He's on a piece of a company equipment. He's drawing money for his services from that company. Would you sue the forklift driver? No, you're suing Costco and their insurance company. Thank you for your time.
Thank you, sir. Thank all of y'all for coming. I know you spent all day, or all morning anyway. I appreciate it. Call it the next panel. Brian Dennis, Fair Oaks. Adam Blanchard, San Antonio. And Anthony Home from Driftwood. My daughter lives at Driftwood. And members, I'm showing this as the last three. We'll call. I have all of these cards wishing to not testify, but the shown position is okay with y'all. Instead of reading them, we'll just put them into the record. Okay, and so please state your name for the record, sir.
Brian Dennis. I'm here opposing SB 39. I am a trial lawyer. I represent those that are injured. And we just had the misfortune of having a trial in February for a lady who lost her husband of 35 years. The driver who caused the event was a Mexican national with a Mexican driver's license with no proof of training. When he was hired, the packet included his name and his date of birth. The date of birth was wrong. There was no testing, there was no training, there was no vetting. He was hired because he was the lowest, cheapest person available to do the job. He was hauling 3 layers down for a company that made plenty of money, that wanted to offload its responsibility and put the motoring public of San Antonio at risk. The company who hired him, the company who hired the person who hired him had a fleet of its own trucks. It qualified its own drivers. It had all of the rules, all the regulations, all of the check boxes. But it couldn't afford to employ everybody, apparently. So they went 3 layers down and they hired this guy. In the course of working the case up for trial and in talking to the police officers involved in this incident and in its investigation, they knew the driver, they knew the truck, they knew the trucking company, a mom and pop shop with 3 trucks. They had pulled this guy and many others off of Loop 1604 in San Antonio countless times over the preceding 7 months. They started impounding the trucks because the citations weren't working, because pulling the people out of service, pulling the trucks out of service was insufficient. As soon as they got back into the truck, they were driving it again the next day. Those companies continued to employ those drivers. That's important. SB 39 limits that ability.
All right, thank you, sir. Please state your, pull the mic over. Go ahead. State your name, begin your testimony.
Thank you, Chairman Nichols. Members of the committee, my name is Adam Blanchard. I'm the co-founder and CEO of Double Diamond Transport and Tanager Logistics, both headquartered out of San Antonio, Texas, and I am here today to testify for Senate Bill 39. First, I'd like to thank, although I know Senator Birdwell is not here, thank him for his authorship of this bill. I was heavily involved with House Bill 19 2 sessions ago, and am now back discussing some of the consequences of that bill that I think we can clean up with Senate Bill 39. I think it's important to begin with of what this bill does and what it does not do. Our hearts go out to the families, many of which you have heard from today, that have been injured in truck accident cases. We as an industry want to compensate those people that have been injured in these accidents to the full extent allowed by the law, and we don't want any bad actors in our industry. But I think it's important for this committee to understand that this bill in no way inhibits people's access to the judicial system. It does not in any way inhibit their ability to be fully and completely compensated for the accidents they're here to testify about. This bill simply allows us to focus in the first phase of the trial on what was the accident, who was at fault, and how do we make this person whole. Senate Bill 39 simplifies the process that was provided in House Bill 19 and in my opinion, removes some of the unintended consequences that have been a result. I think both sides could agree that the fact that those regulations that are mentioned in House Bill 19 that are currently in statute, they can only be introduced into evidence as it relates to the negligent entrustment claim. Those certainly should be introduced if it relates to the negligence of the driver. And so I think this bill very much cleans up some of those unintended consequences and in fact allows more evidence to be introduced in the first phase of trial in support of those that have been injured. I think it's also important to note that 72.054F, I know it was mentioned before, related to negligent.
I need you to close.
Sorry. That they still can go after the companies for those reasons. Right, for these reasons, I ask for your support of Senate Bill 39. Thank you.
Thank you. Please state your name.
Yes, sir. My name is Anthony Holm. I'm opposing to the bill. I'm here on my individual self. I happen to be a trial lawyer, but I'm also a truck driving school, graduated, qualified on hazmats and tankers. I'm one of the people, probably only in this room, who's successfully driven a semi up and down 35, where they're referencing those deaths in the last 5 years. This bill, though small, strikes this many federal regulations from admission in phase 1 of the trial. So here's what we have. We have CFRs. The federal government said, hey, trucking is so dangerous, so many people are driving 70,000-pound weapons 70 miles an hour, we're going to have minimum standards. And here are some of them. These are currently admissible in phase 1. They will not be admissible if this bill passes. And there's 30 or 40, but there's 12 or so that I want to make sure that you guys are aware of. Some of them have come up. Admissibility of can't read or speak English. The admissibility of, do they have a valid CDL? If those aren't proximate harms of the injury, then they won't be admissible if this bill passes. Amphetamine use 3 days prior to the crash, that's not going to be a proximate harm today, but if somebody's been up for 36 hours, I think this body might be inclined to let the jury be aware of that. You're being asked to vote to oppose that. I've got 12 or 15 that I think are substantial. 0.04 blood alcohol. It is, this just cut off.
We didn't do that. We didn't cut it off. Keep going.
Okay. It is, for example, illegal for a truck driver to drink a few beers before they go on job. Probably makes sense, even if they're not intoxicated. That won't be introduced unless it's causative, unless it's proximate cause of the harm. And it's amazing, I think, that this body's being asked to vote. If somebody shows up half drunk 4 hours before they go on their rotation, that's not admissible because that's currently the law. And there's a whole bunch of others. Texting and driving, phoning and driving. Yes, sir.
Thank you very much.
Yes, sir. Thank you. And I'm open for questions.
No questions. You do have a question? Senator Hagenboom.
Mr. Blanchard?
Yes, Senator.
Appreciate your testimony. I appreciated you being a trucking company owner, but expressing your heartfelt concern for the folks in these accidents and your desire to express that. And we do, your point that you don't want those going on, and and you want full prosecution of those people and those trucking companies that are bad actors. And you believe this bill will let them off the hook or any way, or make it harder to go after those kinds of trucking companies?
Senator, not at all. In fact, quite the opposite. I think that this bill, and to, I guess, rebut the testimony of the gentleman next to me, is those regulations that he just mentioned, evidence of those, every single one of them can come in. It can come in. If the driver was intoxicated when the accident occurred, certainly that's going to come in. If he was texting and driving, that's going to come in. All of the things that they shouldn't be doing, according to our federal regulators, are going to be a component of the cause of the accident that will be introduced. And so this bill in no way inhibits people's ability to file suits against trucking companies. It doesn't in any way inhibit their ability to introduce evidence at these trials related to what was the cause of the accident, who was at fault. In fact, in the second phase of the trial, just like a criminal case, they can bring in everything to punish those bad companies. And in fact, I find it very interesting that many of the people that have come here to testify before you in opposition of this bill are not discussing the fact that the law as it is currently sits today.
Okay.
It was part of House Bill 19. Limits
I think you answered his question.
their evidence on
Did you have
coming
another
in.
question?
Yes, sir. Someone talked about, one of the previous people talked about the free market impact of this. How do you think the free market is working in terms of how the balance is working out between trucking companies and their economic success or ability to survive and law firms, trial law firms?
If you want to talk about true free market economics, we are losing resoundingly. In fact, none of the insurance carriers, we're seeing many leave the state of Texas as a result of the litigation in the state of Texas. It is causing trucking companies to go out of business at a disproportionate rate to free markets. And in fact, it is making the roads less safe. I have 4 children that are on the roads with my wife, and we now have to have less insurance. It was mentioned earlier about punitive damages being excluded from many policies now. That's because of the litigation environment that we're here to address. In addition to that, many companies like mine, I run 90 trucks. I'm having to now take the first $75,000 of every claim myself in order to get the insurance at a rate that I can afford. And so the suggestion that this is just here to help big insurance companies is just fundamentally flawed. Many of us now are having to retain the first $75,000 or $100,000 of every lawsuit and every claim that we have. And so it's hitting us in our pockets and the people in which we employ in our communities.
All right, thank you. Thank you. I appreciate this. Appreciate all y'all coming. Is there anyone else here who would like to testify on, for, or against Senate Bill 39 or the committee substitute? If not, we'll close public testimony. We'll leave the bill pending. Chair lays out Senate Bill 2246. Ask Senator West to very quickly lay out the bill.
Very quickly. Members, this deals with salvage auto dealers routinely purchasing vehicles from law enforcement auctions and foreclosure sales held by lien holders. Frankly, what happens is that being able to get a title to these types of bills is frankly ridiculous, because the fact is that they will never return to the road. What this bill does is allow auction sales receipts to be used to establish ownership, and will allow salvage auto purchasers to avoid the time-consuming process of obtaining a title for a vehicle that ultimately may be scrapped or destroyed.
Any questions, Senator West? If not, we'll open up public testimony. On Senate Bill 2246, I have resource DMV. I'm not showing any witnesses. Is there anyone who'd like to testify on, for, or against Senate Bill 2246? If not, we'll close public testimony. We'll leave the bill pending. Senator Betancourt. Chair lays out Senate Bill 2722. Recognize Senator Betancourt to explain the bill.
Thank you, Mr. Chairman. Members, I'm going to do a very abbreviated layout because we have a witness, Tom Ramsey, who Commissioner needs to leave. Senate Bill 2722 is a bill to bring clarity and transparency to the use of excess toll road funds in Harris County, amounting to hundreds of millions of dollars a year. I first noticed this issue when I found $170 million of excess toll road funds was being used for facilities such as parks, pools, et cetera, and other non-transportation uses for the Hardy Toll Road Connector Project. Several investigative reports of waste at the Harris County Toll Road Authority you'll hear about in testimony later today. And no effective audit of expenditures exists at this point in time. All got me to file this bill and the committee substitute, which I send up at this time. I'm sorry, Mr. Chairman, if you could acknowledge me on the committee substitute.
Senator Betancourt sends up committee substitute for Senate Bill 2722, and we'll explain the differences.
And thank you. I assume that this will have a lot of time to explain this after the session, but effectively 70% of the excess toll road revenues will be distributed to the county, can only be used on county-owned and maintained roads. There's also currently a pattern of 95% to be allocated to the precincts. In addition, 30% of the excess revenues given to the city of Houston. They've answered approximately 2,290 calls on these roadways. We'll hear more from them. And an audit can be done by the state auditor with penalties as necessary per the substitute. And with that, I'd like to bring up Commissioner Ramsey before we lose him around 11 o'clock.
Okay, you can come on up, but is there any members have a question of Senator?
We can.
I have a couple of questions.
Or Senator Miles.
Is that okay? You got time?
Well, barely, but I'd be happy to answer them after session. Either way, Senator Miles.
You got time? Thank you, Mr. Chairman. Being the only other Democrat Harris County person on this committee, I've got a few questions, and I'd like to ask them if you let me, if you allow me.
Absolutely.
Okay.
After 11.
Senator Betancourt, this bill allocates 30% of the Harris County toll road money, mobility transfer fund, to the city of Houston. Is that correct?
That's correct.
And what is the justification for the 30%?
Senator Miles, if we could, I'll be happy to answer all those questions after this, but I'm going to lose my witness here. He's got to leave at 11 o'clock, and we're going to be back up.
Your witness may want to hear some of these. There's only three more.
He can. Okay. Yes. The answer is yes. That it allocates 30% to the city of Houston.
Question was, what's the justification?
Justification is the number of calls that the Houston Fire Department and the police have done on the roadways. We'll have testimony from the fire chief and also the police chief on that.
Okay. Then why does this bill allow the city to do something with the revenue that the county is restricting from doing?
I think that one of
that makes no sense to me.
One of the suppositions I came to was that public safety should be a priority for these excess funds.
And you don't think public safety being done by the constables is a priority?
Not in this particular case because of the jurisdiction element of the Houston police and fire on their roadways.
But the constables have had jurisdiction over the tollways since their existence. Is that correct?
Yes, but they're generally there for more of a traffic citation. What happens is the HPD and Houston Fire Department does the basically emergency response on those tollways.
I'm not knowing how you justify emergency response, but does Senate Bill 2722 require any audit requirements on how the city of Houston uses these funds?
I believe that all these funds will be auditable, including the HECTRA funds, and I'd be happy to make sure that the city funds are audited as well.
Okay, and does this bill include any transparency measures or any financial oversights to ensure that these funds are being used properly?
That's what the whole purpose of the audit section is, and be happy to go into great detail after session.
But there was nothing in the bill about...
No, it's in the substitute. That's just...
It's in the substitute, okay. I look forward to seeing that substitute. And last but not least, Harris County has 34 municipalities, but this bill seems to only give one municipality a percentage of the county's revenue. Can you explain that to me, sir?
Just in short, that's because of the police, 6,514 police and fire responses by HPD and Houston Fire Department on those roadways, and that's the other jurisdictions have a far less number.
Can you drill down just a little bit further for me on that? We have 34 municipalities, but it seems like one municipality is going to get the bulk of this money.
That's correct.
Explain to me why.
That's what the whole bill layout is, and I'd like to defer to my witness before I lose him.
But you wrote the bill, right?
Absolutely.
Okay, we'll defer to your witness at this time.
Thank you.
Okay.
Thank you.
Nathan, you had your light on for a second. Then
Just out of respect for the witness, I'll save it till after the session.
Thank you, Mr.
Thank you. No more questions from the panel, then we'll open it up for public testimony. Commissioner Ramsey, you're up here. You were the first one, so please go ahead and testify.
My name's Tom Ramsey, Harris County Commissioner, Precinct 3. And Chairman, thank you for allowing me to speak quickly here. Senator Betancourt, thank you for your work on the bill. I am here in support of the bill. And first, let me make it clear, HECTRA is a well-run agency. that I've had over 40 years of experience. I can speak with some understanding. Chairman, I'm from East Texas, engineering background, have worked with the Toll Road Authority for those years. I understand it very well. I think they do a good job. It's important, I think, for the future of Harris County that we have funds available to deal with the unincorporated area. I'll be speaking first to this part of the bill that deals with the unincorporated area of Harris County. There's more people live in the unincorporated area of Harris County than live in the city of Houston. And 75% of that area is in my precinct. So the bill speaks to the statutory responsibility of maintaining those roads. My precinct has 47% of the county roads in Harris County, yet I get less than 25% of the funding. So the bill that I'm supporting here deals with that they would disperse the funds based on the county road responsibility, which in my case is 47% of the roads is in Precinct 3. I'm being severely underfunded. I have over $300 million worth of projects to be done and have no funds to do them. So it is a growing part of the county. It's important that we deal with this. This bill does, I think, specifically deal with that. Obviously, it also gives the city of Houston 30%. That's not necessarily mobility and probably have some concerns related to that. But at the end of the day, over $200 million a year in sales tax is sent from the unincorporated area of Harris County to the city of Houston to help mitigate, I think, any issues there. So the part that I really want to be clear on, this bill statutorily defines that the county road maintenance should be done, and the funds, the surplus funds dispersed amongst the 4 precincts should be done based on the amount of county roads in your precinct.
Thank you. Senator Miles?
Thank you, Mr. Chairman. Commissioner Ramsey, is it true that each constable for each area has contracts on these tollways?
That's right,
And they're the ones that are policing these tollways, correct?
as I understand it.
So you want them to continue to police them under contracts and not receive any of the funds from the tolls? Is that correct?
I
Is that how
want
you're
the
saying that?
constables to continue to do that. My focus is on the distribution of the surplus funds. Currently, I'm not getting
Surplus
my fair
funds.
share. Yeah. When you distribute the funds, when there's a surplus, and that's what the bill's about, when you distribute the surplus funds, it's not being done according to the amount of county roads. I have 47% of the roads. I'm getting less than 25% of the funds.
So if that's the case, wouldn't it be easier, Senator?
Let me try a little history here. I've watched this thing since the late 90s.
Yes, sir.
I've used Harris County Toll Road System as the model for the state. They've done an outstanding job. I know Judge Lindsay, later Senator Lindsay, worked on it. The county did it. The citizens approved it. The county commissioners court runs it. They are the ones that are responsible. Unlike some of these others that have boards, it's the commissioners court. And they built the system. They've expanded the system. They've taken great care of the system. And beginning, let's call it, I may be slightly off, but a decade ago or so, they've got the lowest toll rates in the state, as I believe it. But beginning about a decade ago, they started to end up with surpluses, for lack of a better word, and they began dispersing. And each year for, I know the first 6 years, $120 million a year was dispersed that went back into non-towed county roads. That's great. I bragged on that all over the state. Somewhere in the last few years, in those disbursements, they began other ideas to use it for different kind of things. And this is where the
Within the county.
Within the county. Began using it for things other than transportation. And so I passed a bill, I don't remember if it was my bill or your bill, I think it was my bill, 4 years ago, 6 years ago, I think it's about 4 years ago, that said specifically it had to be, if it was dispersed, it had to be spent on non-towed county roads and related projects, which I'm thinking drainage, that kind of stuff. Those funds then kind of crept out and they were used for different kind of things. And so we're only talking about the funds that are dispersed, not the operation of the tow road, but that which gets dispersed. What is the proper disbursement of that?
Correct.
And so.
Of the surplus fund.
Of the surplus.
Of the surplus fund.
Surplus excess.
And that's what the bill is really dealing with.
Don't you think it should be equally dispersed amongst the precincts, that all of them equally dispersed?
I'm not, that's his bill.
Don't you think, Senator Betancourt, it should be equally dispersed?
We'll show, I have some mathematical formulas that show what the result is currently with these excess funds and what it would be passing the funds, and basically aligns with the county road miles and puts a priority on the county-owned roads because they're the only ones that the county has the primary responsibility because there are no other cities.
I look forward to that. I just want one question. Don't you believe they should be equally dispersed? The surplus money should be equally dispersed throughout the county.
Well, it's historically not been, and this bill has a much better pattern, which I think you'll like them.
If it's
You'll be
historically
surprised
not
when you see the
been,
numbers.
shouldn't we be putting a bill together that does?
Well, when you see
It's
the
only fair.
numbers,
It's the right thing to do.
Senator Miles, when you see the numbers, I think you'll be surprised.
Okay. But
all right.
you agree with me they should be equally dispersed?
No, I think we've got a really good pattern in this bill that I think I want you to consider first.
So you don't believe, but okay. I look forward to your work.
Senator Miles and everybody, I only went ahead and opened this up so Commissioner Ramsey could answer any kind of questions. We're going to have to, as soon as we take a break here, I'm so sorry I'm not going to be able to get to everybody else's because we were supposed to be in the floor 5 minutes ago. But I promise you, we're not going to rush this thing. We're going to come back. And so I'll begin the early stages of an announcement. Be watching the floor at the end of our work at the floor today. I will announce when we're coming back. We'll be coming back to this room, and we will take our time, and we will go through this methodically.
Thank you, Mr. Chairman.
Is that fair enough?
That's fair enough. Thank you, Mr. Chairman.
Okay, anything else you want to say
I've got one
before you
question
leave?
for him before.
And thank you, Commissioner Ramsey.
We are keeping the door open upstairs. Tom, you've got, your priority was, you've got over $300 million of projects that you cannot currently handle, right?
That's correct.
And these are predominantly in unincorporated Harris County.
All in unincorporated Harris
Right.
County.
And there's other precincts that have unincorporated areas like Commissioner Briones, et cetera.
Right, but mine is 300% more than some precincts.
Right. And I think you've seen the mathematical calculations that other witnesses are going to hand out, and you would agree that that would align the excess toll road funds with the road miles in your precinct.
That's correct.
All right.
I would also encourage you to let's make sure everybody has a copy of the committee substitute,
Right. Well, that's
and they'll have time to study it some during while we're on the floor.
why.
Okay?
Sure.
All right, is that fair? All right, so much, thank you very much
Thank you,
for
Chair.
coming. I apologize to everybody, but we have to get to the floor. But we will be coming back, we'll methodically go through this,
There we
be
go.
patient with us.
The bell.
With that, we'll leave the bill pending and recess, call of the chair. I'll announce the time at the end of the floor.